Yes.
Contempt application, my lord. Lordship has heard this contempt application prior to the application. Lordship directed to appear the matter under the same heading. Lordship 1 week after reopening of the puja petition. I have enclosed the server.
My lord, may I be permitted to mention one matter, a compromise petition which was mentioned on Monday and it was fixed on Tuesday, but it was to be coming under to be mentioned. My lord, the state advocate is present with me. My lord, kindly fixes it under the heading of hearing, my lord, tomorrow anytime.
Why?
My lord, because the hearing is pending, the can application or
in the
compromise
list?
petition.
Is it in the list?
My lord, it is not coming in the list. It was supposed to come on Tuesday, but maybe the record was
There
not.
is a compromise. What is the necessity of hearing further? That is why we kept it as to be.
My lord, for orders then, my lord.
No, how does the nomenclature disturb you, madam? You want disposal of the matter on the basis of the order. It will be there tomorrow as to be mentioned.
To be mentioned.
Deeply object.
My lord, may mention one matter. My lord, it is
Yeah,
without. My lord.
Who is your other side?
My
The
lord,
other side is here. He compromise.
My lord, it is a land acquisition matter, my lord. A writ petition was filed, the acquisition had lapsed, then a state had preferred an appeal. It had also lapsed in the appeal, and then they preferred an SLP before the Supreme Court.
Acha, what is the compromise now?
Now the compromise is the exchange of land. The land that the state had acquired, instead of that, they are giving us other lands. So that is the compromise that have been arrived at between the state and the parties. My lord, and the compromise petition has been affirmed by both the parties and filed.
কালকে একটা to be mentioned পারলে দিও. Keep a watch on the list. Yes.
Deeply objected.
My lord, without certified copy, due to urgency, I filed this application memorandum of appeal, my lord.
The order was passed much
On
earlier.
29th September, 24th September, I applied, my lord. I am not getting certified copy. Your lordship, earlier I mentioned, I am trying to base label based one, not yet applied.
Leave that. Yes.
Lord, on 27th September, your lordship directed the matter to be placed after vacation. On Monday, I mentioned your lordship, my lord, directed me to give a notice and then mention. We have given a notice, my lord. It should
Now was happy.
mandamus appeal. Given notice pursuant to earlier direction.
My lord, I need to mention one matter. My lord, for inclusion in the list,
Where is
the
your
urgency
notice
is
to
that
the other?
my lord,
Where is your notice to the other side?
my lord, the notice has been served. So far as
That you are mentioning
instruction has been
today.
given to me.
Have you given notice that you are mentioning today?
No.
Give a notice and come back next week.
My lord, may I mention, my lord, I have started the notice. It's supposed to come on 12/11/2024, but it didn't come in the supplementary rates. And the interim
That is,
order,
is it WPCT?
WPST,
So
part
please-
that matter, my lord.
What happened? Interim order is still?
Interim order is, it will be over in the month, in this month only, my lord.
In this month. The to be mentioned extension of interim order দিয়ে দি
My lord,
কালকে থাকলে
it's part that matter.
কালকে পারলে
Any objection,
May I permit to mention inclusion in the list?
what matter?
The FAT 747.
It is a mandamus appeal or a writ.
Read.
What happened? It never appeared earlier.
No.
Fresh matter.
Yes, Lordship.
We have filed the motion.
I have.
Give us the slip. Madam, you have to check up the file and mention. Please,
It is of 2019.
don't accept slips given by the clerks. First, go through the matter. The FMA. What is? Have you filed any application in connection with the appeal?
I have no instruction, Lordship.
Please take instruction. Ascertain what you are mentioning. Give a notice to your other side and mention. Yes.
We may have lordships kind leave to mention an mandamus appeal in the original side, my lord. Lordship's original side officer is present, my lord. Lordship may
Notice to your other side.
it is upon notice, my lord. Lordship may take up.
But land.
No, my lord. This is Group 6 service.
It will be after 2 weeks because my brother won't be there. Regular
Very well,
bench
my
will
lord.
not be there for 2 weeks. Sahib Phille remind. Yes.
My lord, may I have to mention, my lord, one appeal, my lord, pertaining to land matter, my lord. I am mentioning with the notice. It was wrongly appearing before the court number 1, my lord. I got released therefrom. I am mentioning here.
Is a fresh matter?
No, my lord, fresh, not
Is
not
the
fresh.
hearing matter?
My-
Have you given notice?
My lord, I have
Other
given.
side notice?
Other side, I am not. I have noticed, my lord.
আসলে combined list দেবে January combined list.
My lord, in month of December, my lord, anyway.
Yes.
As you
My lord,
lord.
learned court officer is considering only one sentence of the honorable previous court's order, and that it was mentioned on 11/11/24 before this honorable court, and this honorable court has allowed the mentioning.
কিছু কাট
It is not being taken up, my lord.
কি হয়েছে কাট
It is not being listed, and this is for my lord waiver of exemption from
What is the can 3?
it is for exemption from paper book, my lord. The previous honorable previous bench have ordered me to go to the legal services for getting the paper book done. I'm not getting salary for 4 years. I went there, they asked me to go to the junior amicus curiae. My senior amicus curiae is there and junior amicus curiae is there. Junior amicus curiae have been appointed and junior amicus curiae went to the legal services. They said that junior amicus curiae have to bear the cost. Junior amicus said, I cannot use do a can and kindly mention it.
Are the pleadings already on record?
These pleadings are already on record, madam.
এটা দিয়ে দিও তাহলে ফাইলটা। We cannot specify the date. Please keep a watch on the list. It will appear.
My lord,
Once the file comes, it will.
file is here, my lord. It was allowed and the file was requisition and file has come here. File is here, my lord.
You are mentioning upon notice to your.
I'm mentioning upon notice, my lord.
দেখো যদি ফাইলটা পাও কালকে দিয়ে দিও। টু বি মেনশনড এই অ্যাপ্লিকেশন হেডে দিয়ে দিও ক্যান 3 উপরে দিও।
Obliged.
Yes, call the list.
Has come at my instance, my lord. My lord.
Lordship, I am for respondent number 1.
My lord's direction was to serve a notice, my lord. Admittedly, my lord, the interim order as that was granted, my lord, it expires its life, my lord, way back in January 22, 2024. No extension, formal extension, my lord, was made. And my lord,
You filed any application for
yes,
this?
yes, my lord, yes, the application can one. Oh, apni ache, atuy ache. My lord, this is
You have got the application.
Lordship, we have got received.
now, my lord, the basis on which, my lord, the order.
But for the
Respondent number 1.
respondent number one is
সেটাই
the why
Petitioner,
respondent? Then
petitioner.
all the applicants,
Only applicant.
all the applicants you are appearing.
Yes,
There
Lordship.
is no one applicant, there are many applicants.
Lordship, I am for respondent number 1, Mr. Manik Lal Kaur.
Yes, yes.
My lord.
Oh,
Applicant in original application.
অ্যাপ্লিকেশনটা কোথায়?
Application টা দিন, my lord, can one.
Can one
Why Sujit Mitra has been made party
yeah.
Sujit.
as personal.
Sujit
Sujit Mitra mentioning his name.
Sujit Mitra is the inquiring authority. my lord.
Inquiring of.
Sujit Mitra is the inquiring authority. Officer. Now, my lord, may I have the liberty, my lord, to file the supplementary affidavit by omission, my lord. My lord, your lordship's order dated 2nd January 2024 has not been annexed. My lord, which is the last order. The last order, my lord, by mistake, my lord, this was not. It is it's an omission on our part, my lord. Then, my lord, as your lordship's specific observation, as prima facie and arguable case has been made out by the petitioner, the order impugned in the present writ petition shall remain stayed till 19th February. Supplementary affidavit, page 4. Now, my lord, this line, my lord, the Mr. Dash, second paragraph, learned advocate appearing for the respondent number 1 in support of his contention has placed reliance upon a judgment delivered by the coordinate bench of this court in case of such and such, being WP city number such and such. Now, my lord, on the basis of this judgment, the honorable tribunal has passed this order, and my lord, arising out of the contempt proceeding is paragraph, page 4 of the supplementary affidavit. Your lordship's order dated 22nd January 2024. Supplementary affidavit.
Just give us 2 minutes, Mr. Basu.
When the interim order was passed,
22nd January.
2nd January 2024.
And this
22nd
continued-
January, which year?
2024.
2024.
Now, what is this SLP which has been?
Milord, ACLP Milord is this was preferred by the BSNL, my client, against the order which referred to your lordships in the judgment in the order WPCT number 38 of 2022. This judgment, Milord, has been stayed by the Honorable Supreme Court. This is the part of record, Milord. They are relying on it. They are passionately relying on it, Milord. Kindly see page 15.
Page 15 of
Yes, page 15 of the Can 1. Can 1. SLP number, Milord.
That order finally disposed of.
No,
They went up in SLP.
No, it stayed, Milord, till further orders, operation of the impugned judgment shall remain stayed.
Final order passed by coordinate.
Final order, the final order passed by the coordinate bench, which was relied upon by them, and on the basis of which the impugned judgment was passed by the Honorable Tribunal, Milord. This judgment passed by the coordinate bench of your Lordship's Court, that has been stayed by the Honorable Supreme Court. So this is the order, Milord, page 15.
So what is your explanation for waiting, for not coming before us for extension?
Milord, since Milord, I tell you, Lord,
Paragraph you have
no,
stated.
Milord,
There is no explanation.
no, Milord,
Not a single line has been written.
no, Milord, I tell your Lordship, since
Check
Milord,
it up.
Milord,
Check it up. Where is
no, Milord, this was
Is there any single line that for this reason I couldn't file the could not file the
No.
extension and then?
no, Milord, since
My
Milord,
lord-
you are under, I tell your Lordship, Milord, two matters were simultaneously heard by your Lordships, this Maniklal and Tapon. Sorry, yes.
No,
So
no,
the
not
Maniklal and the other one, this is not appearing. Milord, the tribunal, this was an assurance, Milord.
No,
given-
what has happened in the other matter? Have we extended? There also must be interim order has expired.
Yes. But contempt adjourn sine die. Because of the Milord assurance given by the learned advocate for the applicant in the tribunal.
So very
Milord,
good. If contempt has been adjourned sine die, what is
no,
the utility of
in this case, Maniklal, the contempt they are proceeding with, because the honorable judge of this tribunal, according to the tribunal's view, Milord, since there is no formal stay, we shall proceed with the matter.
Yes.
My lord, this is a ill-advised application. My lord, this application is moved after 9 months. Actually, my lord, the interim order expired on 19th of February. My lord is aware of it. And lordship, we are relying on, we have cited a judgment, Tapan Das, but we are not dependent on this. We are dependent on our own grounds, lordship. And lordship, if lordship remembers, lordship has asked for some, citing some judgments of Honorable Supreme Court, which we are ready for it. And
When
along
is
with
the-
it,
When is the contempt matter fixed?
26th of this month,
Of this
26th. And my lord, this contempt, stay application is moved just after we have moved with the contempt application, and the learned tribunal has given direction for
Your officers
filing.
think that whenever I will go to court, court will pass an order.
No, Milord.
my lord.
We were not inclined to
No,
pass
no,
order
Milord,
also.
In
at
fact,
that
my lord, for
Milord,
Tapan Das matter also, or
You
in,
insisted that please hear out the main matter.
Yes.
My-
We committed that mistake. We believed everybody. We started hearing and fixed the matter. Your officers
No.
cannot be in a
Milord,
such a
Milord,
lackadaisy
I tell you,
manner.
Milord, I have no
Wrong
explanation to.
signals to the client. Mr. Basu, you are appearing. It is okay. When you submit something, we will take it that you are saying this was the general. But your officers do not think in that manner. Pay cost of 1 lakh, we will extend the interim order.
Milord, kindly, Milord.
Oh, no, they should be.
Milord,
They sit in their office. They do not take steps, and the advocates are embarrassed. You are being embarrassed by
yes,
these words.
yes, Milord, Milord, I tell you, Lordship, Milord,
my lord,
only
even
are
for
two
Tapan
submissions.
Das, even for Tapan Das, my lord, if I may add one line, my lord,
Your officer, he doesn't have this much of sense that my interim order will expire. Let me contact my advocate. What can be done? And there is no explanation. Today, if we extend the interim order and it goes to Supreme Court, the first question which will be asked is, where was the pleading? Isn't it so?
Absolutely.
For that reason, we will be embarrassed.
Yes. Milord, I tell your lordship, Milord, if your lordship is not minded, Milord, Milord, I tell your lordship, Milord, without
No, no, we are not mind because this application you show us one line that this is the reason why I waited for 9 months to file the
Milord, then
application.
permit me to file a supplementary affidavit, Milord. We will explain. No.
This way it cannot continue.
No.
Just because you are appearing
No,
for
no.
the authority,
No.
authority thinks that whenever I go to court, court will intervene.
Milord, I have no
You are
explanation to
talking
offer, Milord.
pension
For
and
this.
other benefits.
No, no.
Sorry,
No, Milord, I have
dismissed.
no, only one indulgence. Milord, give me one minute, Milord. 1 minute, Milord. Milord, first of all, Milord, my learned
We
friend.
are inclined to give you 1 hour, but that will not remedy the situation because your officers are totally acting in a lackadaisical manner.
Milord, I tell you,
Who is
lordship.
the officer? BSNL officer. He sits in his office and he doesn't know what is to be done. And not even a line. দেখো তুমি পেয়েছো কি আমি পাই
No, Milord.
Not even a single line. That's my lord. This was the reason I couldn't fight.
Yes, Milord, that is true. That is true, Milord. Milord, Milord, only Milord.
Who has Mr. Soumojit Mishra is the advocate on it. So, sir, you will not ask your client that tell me what is the reason for this belated approach. I will write that down in the petition. For his latches, you people are being embarrassed.
Yes, Milord. Milord, only Milord, if your lordships are not minded, Milord, to extend, Milord, kindly give us a chance to address your lordships on in the matter. Milord, since Milord the observation, Milord, it is. May I? Milord, only thing, Milord, if your lordships, Milord, kindly takes
When did we keep the matter returnable?
26th.
Did we fix any date?
26th.
hearing of
No,
the matter?
your lordship said that let the matter further 7th February. This was the 2 p.m. 26th, Milord, kindly takes it up at 2 p.m. 26 2 p.m.
26 is the contempt matter at the learned
I
tribunal.
will address your lordship, Milord. Milord, I tell your lordship, Milord.
No, sorry, Mr. Basu.
Milord, only one indulgence, Milord. This is a clear case, Milord.
You should appear before the tribunal and explain.
Milord, only one indulgence, Milord. Just, Milord, for a
Mr. Basu, allow him to be embarrassed.
Milord.
This person, he
Yes.
needs to be appropriately dealt.
Milord, we are all working through human agencies.
No.
Milord.
That we understand what you are working for. You are working for your clients.
Yes.
But you are protecting a person knowing fully well that this person has a lackadaisical attitude
Milord,
towards the court.
it is
Your first duty is
yes.
to the court,
No, yes,
not
yes.
to your client.
No, yes, Milord. But Milord, if your lordship, Milord, kindly have the charity to consider this only 3 lines, 3 paragraphs. I will try, Milord. Only 3 paragraphs. Your lordship's page, Milord, 4.
Supplementary.
4 supplementary affidavit. 4 supplementary affidavit. Mr. Basu, learned advocate, appearing for the petitioner. My Lord Justice Chakraborty, no explanation. This is true. But Milord kindly says, Milord, the other side of the coin, heard Mr. Basu, learned advocate, appearing for the petitioners at length. Milord, the order was passed in presence of my learned senior friends. He is directed to avail necessary instruction as regards the pensionary benefits which are being paid to one Tapan Kumar Das, who appears to be similarly situated to the respondent number 1 herein. Mr. Das, learned advocate appearing for the respondent in support of his contention, has placed reliance upon a judgment delivered by the coordinate bench of this court in the case BSNL versus such and such. Milord, Mr. Basu submits that the contempt application has been fixed for the learned tribunal.
This WPCT against this SLP
was done. Milord, this is the judgment, Milord, of the coordinate bench, Milord, presided over by Justice Tandon. This is the, Milord, the sheet anchor of the applicant.
To ask your officer to be personally present tomorrow and explain to us what he was doing. He was sleeping or he was not in office or what has happened. Who has affirmed this affidavit?
Shyamol Kumar. নামটা বলুন সামন্ত না
They are so busy officers
Rajiv Dutt.
Only the advocates have to appear and get embarrassed before
Yes,
the
sir. No,
court.
no, Milord, only, Milord,
No, no,
Milord,
you ask your officer who has
Yes.
affirmed this.
Milord,
Let him come before us.
Rajiv,
Rajiv Kumar Dotto
yes.
and
Yeah, okay.
Shoikat Das. It is your choice. If they appear, we will hear him and then consider.
Yes, Milord.
To be mentioned, Kalke rekhe daw. And
Deeply
if he
obliged.
doesn't appear,
Deeply obliged. No, no, no.
steps will follow.
My lord. My lord.
Mm. And we make it clear, if they are not here, we will not consider your application for extension.
No, no, Milord, tomorrow at 10:30. Yeah.
Ask your junior
No,
to
no.
take down
Yes,
the
yes.
names and they should be here first, 10:30 in the
Yes.
morning, standing here in front of the court.
Yes.
These people, they think retirement benefits, they are stopping.
No, Milord.
Lackadaisical attitude and advocates get embarrassed for this sort of clients. Very unfortunate. See how many words we have to say to you.
Milord, Milord, this is, Milord, this is a.
You are a counsel.
No, no.
We have total faith on you.
No, no, no.
The thing is, why this adamant attitude? Why this audacity? Why this audacity? Why the government officers will not think that this is High Court? Come, if they do not come, we will deter ourselves from extending subject
My
to
lord.
hearing.
My lord.
Yes, next.
Grateful.
Huh? একটা extension আছে করে দাও, extension orange.
Yes. After a long time before your lordship and Shubho Vijay and Deepavali. Milord, I am for the respondent one, Milord. Very peculiarly enough, Milord, I was given an email on 18th that the matter will be mentioned on 20th, yesterday. But yesterday was not fixed for mentioning. They have, without mentioning, the matter has been listed. First of all, your lordship agrees, I am agreeing with it. Without mentioning, they had to send the email that it will be mentioned on 20th or very soon thereafter. Yesterday, your lordship noticed me. I was sitting there because yesterday was not mentioning that. And today they have come. I have been surprised that it is under heading extension of interim order. And just like retail benefits, you were stressing the same matter, Milord. They have brought one stay order against the writ order that there was a direction upon the WPTCL to expedite all retail benefits, all promotional benefits. They have not complied with it. I have filed CPA and contempt application. I have filed contempt application, Milord. Yes, yes. And I am very much justified. They are depriving my total
Sir,
button.
it is a mandamus appeal. Group 6.
Is this
It's our determination.
Yes, it is a group 6 matter. The very short point is involved. Lordship. Promotion after he has retired. Now the promotion, he has been given 6 chances to appear before the promotional authority because it is on the basis of APS, Assured Promotion Scheme. He earlier was an employee of WBACB when the entire generating system and the distribution system was in common form. Then WPTCL has been formed being the generating unit and thereafter he given his option to come to WBPDCL. At that point of time,
all the pleadings are complete.
All are complete.
They are already on record. Already on record.
Record means lordship, yes.
The stay application.
Stay application all have been filed. All.
That is
all are there.
Milord, if your lordship
And lordship
kindly as your lordship directed,
So,
we shall comply with it.
This,
But perhaps
they are bad people, sir. You are fighting against bad.
Milord, don't call me sad. Don't call me sad. We used to take your instruction.
Tell us all the pleadings are on record.
Yes. All are pleased, yes.
So very good. We fix a date for hearing and finish it up.
Yes, lordship.
Get
Nothing.
full to your lordship. Get full to your lordship.
In the meantime,
No extension.
Our lordship is here. We shall comply with the lordship's order.
আমি বলিনি
Our lordship fixed for
No,
hearing.
no, no, sir.
আমি বলিনি
You are, sorry, your surname is
Pal, my lord.
Mr. Pal. There was a finding of a coordinate bench that there is a prima facie case. That period of interim order was for 8 weeks.
8
So
weeks.
it is still survived. Mr. They, maybe there has been miscommunication. Did not write in the notice.
Yesterday they had
Very good. We are fixing a date for hearing as all the pleadings are on.
faithful to lordship, faithful to
Until
lordship.
such time, we will extend the interim order.
I'm
For a
different.
limit.
Here, no, one thing, my lord, I am thinking just, I shall waste only 2 minutes time. Writ order was passed by the Rajababu Chaudhary, directing them to expedite all promotional benefits within 2 months. They have not done it. We have filed contempt application before the court. In the meantime, I am surprised they have filed an appeal, my lord. And in a surreptitious manner, they have brought the stay order, my lord. Pensionary benefit.
Okay, we shall apply our mind and
Yes,
then we
yes.
shall take up. for-
I am seeking forgiveness. I am seeking
We are thinking about the fixing of date either in the last part of the December according to our
as your lordship directs.
or in the month of January.
In the month of December, as your lordship directs. But,
December, we are
but
thinking
my client is suffering, lord. He is not getting any money after retirement.
first part
Why?
we already-
Oh, you have got the money in respect of the.
Your lordship
Fixation of
is
scale, fixation of scale, what was there, he is
no,
got
no, no,
everything.
no.
He
They are
is getting pensionary benefits. now.
Whatever
no, 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 my lord.
The admissible dues according to you have been paid. That has been paid.
My lord,
Your
higher-
lordship so wishes, I
has
can
been rejected
take the
because higher pensionary benefit has been rejected.
You want notional benefit of fixation of APS or anything, and accordingly refixation of your pension amount. It is the dispute.
And that they have already discarded our application for pension, my lord. And they are not complying with the
So we are fixing it
Can
to January.
one of
in the month of December, my lord, as your lordship directs.
has the
December last part.
It's very better, my lord. I am the trial court practitioner, criminal court trial court.
has been filed in
the lighter,
connection
but
with
let us have the cakes.
appeal
Then we will
praying
get the
for
entertainment.
extension of the interim order
Yes, I am very happy with that. I have not become so big. I have not become so big.
Lordship, only one indulgence. There was the direction of the learned earlier honorable division bench to file the affidavit in service by serving all the
ওপরে
cooperations.
দিয়ে দিও এফিডেভিট অফ সার্ভিস কমা অ্যাজ ফাইলড কেপ্ট অন
I am developed.
With permission, with permissions.
January
বড় matter.
2 p.m.
Yes.
31st January.
3 ডাকো
Three, my lord.
So for 3 is concerned, my lord, if my landed trades served us the 1, 2, 3, 4 applications and that FMA, because only we have received this, the letter and the order of his lord.
Served directly through speed post, my lord, upon the authority, my lord. And my
what
lord,
are the applications what are the
but application for restoration, my lord.
4 applications I
One
filed
for
and
restoration,
FMA.
one.
Give me the copy of
section-
paper book and application.
I'll give, my lord. Let it be restored, my lord, and with the file, I'll serve everything. I've already, this is my affidavit service, my lord.
কপিটা তো দেবে
That,
কপিটা তো দেবে
I've already served, my lord.
you have served
Yes, and I already filed my affidavit service on the earlier occasion, my lord, on 11th, my lord.
Because
Thereafter,
in the GP office, my lord, there is no record. So that's what, my lord, this has been only.
but kindly
my
see
lord,
the
I
early,
have-
Mr. Basu, are you opposing the restoration?
Restoration I usually don't know.
then, my lord,
When was it dismissed?
but dismiss, my lord, on, my lord, kindly come to, my lord.
October 2000.
Yes, yes, my lord, but come from paragraph 7, my lord. I was not been notified because, my lord, usually it's our practice to see online through the name of the advocate, myself, my junior's name, whether any matter is appearing. And, my lord, on TK Bandhavada's name was appeared with regard to this matter. This is today also, my lord, TK Bandhavada. Nobody is TK Bandhavada related to this matter, my lord. This is the difficulty, my lord. Online checking.
টিকে বন্দ্যোপাধ্যায় vis-a-vis Mr. Bhattacharya.
I do not know. I don't know him, my lord. But he ought to have been appeared.
But it's not a count on that date. You should have understood that court.
And I can,
He did not accept your count to be there sufficient to be misled.
yes.
It is not so misleading that you will.
But
be,
how could we every day we check
locate your.
every day we check the list online, my lord, in the evening, my lord, for the next day, my lord. And, my lord, we check our
The
name.
number is correct. When the
How
cost
could-
title is correct, only name of
Not-
advocate you are using is
It's
at
not
the count.
possible to check every number, my lord.
If you are using is.
But kindly appreciate, my lord, it's not possible to check every
On that
number, my
day-
lord.
97.
This is a difficult. But I have
আচ্ছা what is can 3?
can 3, my lord, the pro forma respondent also died. Pro forma is my sister, my lord. He's our party. He died, my lord, long ago, my lord. And
এই দিয়ে
আপনি hearing can one.
আমি সব দিয়ে দেবো তোমাকে। সব হয়ে গেছে।
Can one and two are.
সব দিয়ে দেবো।
ওই বসু মল্লিকের নাম দিয়ে দিও।
These are the applications
I think we have.
Monthly is of January. This is.
We know that, sir. Is it very difficult for you to wait for 10 minutes? Huh? You have other matters in other, then please you leave. Huh? The court is here, the list is here, we know which one is to be called.
This is an
You
application.
are so busy people that you cannot wait for the court to call you. Huh? We in our practicing life did not even venture to say such things to the court. You have fixed it at 11 AM, you are forgetting. Sir, what sort of practice is this? We will not take the matter. Go let it. কটার সময় 11টায় fix করেছো? Combined monthly list of January করে দেবে।
Well, kindly do not take. We are apologizing. Kindly.
But sir, have some respect for the court.
Well, kindly, Millet.
এটি কি আছে? Yes.
Application for.
Oh, Mr.
This is my affidavit of service.
Delay of for how many days?
Delay of 73 days, my lord. Only one thing, my lord, I am sorry. In the matter, there is a
You
report.
have said only one thing.
My lord,
আবার কি one thing?
one thing. There is a report has been called for, report submitted. I want to file an exception to the report. That
Okay.
restored করে দিল তো।
I will go can 1 and 2. Look, I am for the private respondent. Last petition, Lordship was pleased to direct us to prepare a list of dates. And that we have prepared a list of dates. And then sending over.
Once everybody exhausted, I took the point of maintainability. I got your Lordship on a 30-second.
But I also have a very short 2-minute submission on the maintainability of the appeal.
My lord,
Besides the merits.
my lord, I appear for the bank from whom the applicant has taken the loan. And my lord, the entire dispute started from the surface action that has been taken. So my lord would kindly allow me to make my submission whenever.
No, bank is not a party here.
Yes. Bank is respondent number 4.
May I just take the list of dates for your Lordship? My lord, kindly please, the first entry of the list of dates is my lord, in 2017, and a leasehold right created in favor of the applicant. Then, my lord, lordship will find on 30/6/2017, lease deed executed in favor of the applicants by the DSDA.
Have you given a copy to them?
Yes, everybody. Then, my lord, in that year itself, they applied for credit facilities, appellant. They applied for credit facilities to the tune of 3 crores, approximately. Then, my lord, lordship will find no objection certificate issued by the DSDA for mortgaging the leasehold property. Credit facilities granted in favor of the appellants by mortgaging the leasehold property. Well, let's kindly see the page 8 of the list of dates. Lordship will find the
No,
loan.
very good, very good. Next, proceed.
Well, this is important because the loan was.
We have not yet heard Mr. Gupta.
Oh, no.
You just give us the broad outline, then we will.
Not- Lordship will then find in 2019,
13 to issue.
13 to issued, appellant bank failed to neglected to pay off their dues. The account was classified as NPA October 27. Then the symbolic position of the property was taken. Challenging the symbolic position, on May 2013, a SARFAESI application was filed before the Tax Recovery Tribunal 2.
May
2019.
2009.
that was the challenge against the
Number
notice.
6.
Challenge against the notice.
Challenge against the position note.
13-4.
13-4. Position notice.
Huh.
They applied before they filed the application before the date.
Yes.
Then, well, a lordship will find February 2021, entry 7, sale notice issued by the respondent bank. Reserve price of the subject property was fixed at 3.13 crore. Respondent number 5, that is me, participated in the auction and declared as successful purchaser. Sale was confirmed in my favor in the February 2020.
Yes.
Then April, lordship will find sale certificate was issued in favor of me in the year 2021. Then lordship will find the appellant challenge the sale.
Yes.
Lordship will see my lord, I paid 3.5 crore for purchasing the property. The appellant challenged the sale by filing an interlocutory application before the DRT. Such petition was dismissed by confirming the sale in favor of respondent number 5. DRT conclusively said that there is no anomaly in the
Very
sale.
good. Proceed.
The order we have already disclosed at page 30.
Yeah, yes. Proceed.
Then, challenging such order, appeal was preferred before the Tax Recovery Appellate Tribunal. The respondent bank applied for mutation and transferring the leasehold right in favor of the respondent number 5. The bank applied because saying that I have given sale certificate upheld by DRT, so give sale certificate. Then the Department of UD and MA, Government of West Bengal, which is higher authority of DSDA, also directed or advised that the leasehold right should be mutated in my favor. Then lordship will see, in spite of above direction, order was not passed by DSDA, and we filed a writ petition before this honorable court, saying that why we are the successful purchaser, give us that. Only after service, when the writ petition was served, DSDA passed an order rejecting the prayer of respondent number 5. However, the factum of DRT order was not applied to DSDA. The order clearly mentions the fact the prayer for mutation was refused cannot be considered at this stage by the undersigned.
What is this DRT order? Which it was passed when? DRT order?
Well, just lordship will find it is the
in the appeal 89 any order was passed.
Yes,
Subsequent.
subsequent. I tell you, lordship. That
No, subsequently means prior to February 22.
No.
That is why you are no. You are saying, however, the factum of DRT order.
DRT order means
what order?
The order.
DRT order was
upholding the sale. Order upholding the sale. The entry number 9.
All right.
Now, my lord, one thing, my lord, I want to, my lord, it's very important for the case. Kindly come to page 21 once. 21 once.
First finish off now. Then we will. Then
here, my lord, one thing. The first rejection order, no notice was served, no hearing was given, and it was said at this stage.
You have read it.
Then, my lord, this honorable court in WPA also requested the learned DRT to dispose of the appeal. And request was made. You dispose of the appeal, and let's see whether there is any merit in your challenge to the sale. Then pursuant to directions, entry 15, passed by this honorable court, learned DRAT passed an order upholding sale in my favor.
Then what happened to your writ petition?
Writ petition is pending still. We have
Oh, that is pending.
that is pending.
That was challenging, pertaining to the earlier mutation order.
Earlier mutation. That is pending. Then Lordship will say that DRAT said also that sale is all right. There is no ambiguity in sale, no illegality. Then they have filed an application under Article 227 challenging the order passed by DRAT. Such is the same is pending before this moment. Entry number 16. No stay, not even move today. Then Lordship will find entry number 18.
No, 17 in terms of liberty granted. Which writ petition is
I
this?
tell you, Lordship, we filed the writ petition.
That is 1409.
We filed the writ petition saying no order is passed. Then when we served it, the order was passed. So my
second mutation order.
No, the first mutation order. We filed it before the mutation order.
Oh,
and as mutation order passed, the writ petition become infructuous. Liberty was given to file afresh, so we filed it. Then when the Lordship will find, DSDA called the respondent number 5, both were called, me and the bank. However, no order was passed by DSDA. At least till date, no order has been communicated to the respondent.
This hearing was for what? For considering the issue of mutation again?
Yes. They called. But as of today, I have not received any order. They are saying that there is an order. But how this order has been obtained or passed, we don't have any knowledge.
This order which is impugned this petition?
No. This order also they disclose in the writ petition. We say we have no knowledge about this writ petition.
That was also a
rejection order. They say alleged order is a rejection order, but we have never received.
Your application for mutation rejected.
Bank's application for rejection, mutation in my favor.
Oh, I see.
Now, this order is never given to us. Now, one of the appellant is also very influential. He is the Panchayat Pradhan of Digha, Shankarpur, Digha area. So maybe that way it is. Now, kindly come to the next. Next, the order impugned before your Lordship. Order passed by the DSDA on the changed facts and circumstances, specifically by order passed by DRT, landed DRT, Calcutta, mutated, transfer the leasehold right in my. In the order which is impugned before the writ court now, from where this application is pending, where clearly says, in view of the order passed by the Death Recovery Tribunal, Death Recovery Appellate Tribunal, this order is passed. So first order, at this stage it was rejected. Now in this order, it is clearly stated, in view of the DRT order and DRAT order, this order is passed.
All right. Thank you. Yes, Mr. Gupta.
My lord would like to tell me for because
we have disclosed the points of law also in the next page. I think after completion,
I will allow you.
My
lord, I appear for the bank, my lord.
Sir, what is your problem? You have any other matter? No. Then please keep quiet and sit down. You will be heard. Please keep quiet and sit down. Yes.
Lord, let me correct one error. Lord, the list of dates number, page number 4, serial number 18. This, my lord, they say that this order, the second order of rejection of the mutation application,
which is impugned in the writ.
No. There are 3 orders. First order, rejection. Second order, rejection. Third order is that. In the present petition, the third order, we question.
Third order is dated to 24th. Page 70.
Third order is at page 81. Oh, 81. Third order is at page 81. Page 81 order is in question. It is passed without notice.
DRT appeal is still pending.
DRAT. No.
Sorry, that appellate authority.
No, not paid.
DRT, that DRAT, sorry.
What is pending here is the civil division petition before this honorable court.
No, that DRAT order was refusal of injunction. Against that, you came in 227. So your main appeal is pending there.
Yes.
So
Therefore,
go and tell that DRT that pray for an interim order not to transfer the property. Today, your first submission was that the sequence of facts would reveal that there was a bitter controversy amongst the three persons. Yourself, the bank, as well as the other person who has come. So your 227 is pending, you said. Now today you are inviting us to pass an order that don't sell it to anybody, which according to you is a very innocuous one. In the
no, first thing is this mutation.
that we will consider that
That has been allowed already. We are
so that is
questioning
a
that.
fiscal record, does not confer any leasehold right to that effect.
That is the actual legal.
No,
position.
Mr.
What your
Gupta,
lordship
please give a thought on this, that today mutation has been done. Mutation is subject to the result of the writ petition. Writ petition is pending. Today, your first submission you made was that you see the sequence of facts and principles of natural justice violated. I was not given an opportunity. So, my lord, kindly intervene, which according to you was refused to be granted. That is why you are here. But from the consistent view of the Supreme Court had been that when it is a matter pertaining to the Surface Act or DRT, we will not comment on this. You make that prayer.
I am not inviting your lordship to make any comment in respect of anything in the DRT pending immediately.
No.
What I say is, we are taking the DRT order to be the basis. My lord, the DSDA has granted this mutation. Nothing else.
Yes, and
Now-
what
now we are
injunction?
granting
Your
what is-
injunction you are seeking is mutation done, etc. Good, bad, indifferent, whatever it is. Don't ask them not to transfer the land to
Lord,
somebody.
I pray for stay of operation of this mutation order, which is passed in violation of natural justice. The first prayer. Second prayer is, as your lordship pointed out, that don't affect any transfer or create any income on this property. That's my second prayer. But first thing, the mutation has to be stayed by your lordship. Otherwise, this is the subject matter of the petition. My prayer is that it should be stayed. Unless that is stayed, my lord, they may proceed further to make a lease deed, register a lease deed
In favor of somebody else.
in favor of the purchaser.
So that is what we are saying, that you make this prayer before in the pending appeal.
My lord, kindly pass an order at least saying the
Mutation will abide by the result of the writ petition, Mr. Gupta.
that means, my lord, the mutation remains.
Right, mutation remains.
The mutation remains, my lord. The authorities will be entitled, my lord, to proceed on the basis that there has been a mutation.
Yes.
Therefore, other rights will be created in the meantime. Many rights, my lord. First of all, the right will be created in favor of the
In
purchaser.
DRAT, Mr. Gupta, you are challenging the very sale issue.
What is pending in DRAT?
DRAT, very sale issue is pending.
In DRAT, I am told
So
nothing
in
is.
DRT it is pending. Their surface is still pending before DRT.
No, forget about the surface. The matter related, my lord, the what
One application is pending before DRT. And another appeal is pending before DRAT.
DRAT conclusively said that sale is good.
Nothing is pending.
Sale is good.
That
But they are
is
making,
disposed of.
yes,
That is disposed of. Now this matter is pending
Pending before
another
DRT.
forum in 227 application.
yes.
Now you are opening another forum. Read petition.
No, because of a new cause of action.
New cause of action is action after stage. After the stage of 13.4.
Therefore, new actions will
After
continue
the stage of 13.4 and sale.
Yes.
It is a mutation is nothing, but an action after stage of 13.4. It is a consequence.
And
It's consequential step.
Absolutely right.
It is not a separate.
Then the mutations will lead to further consequential things. I am afraid of that one. Mutation will lead to creation
So
of
that part, we are thinking whether opening of another forum or invocation of 226.
not on your time.
We are clear, we are want to be clear whether invocation of 226 at this stage will be justified.
I say yes because
When a SRPC application is pending and the issue of sale also will be tested in a 227 application which is also pending. Now you opening another forum, stating that mutation has been done.
the scope of adjudication before DRT is very limited. It cannot, my lord, pass orders, setting aside an order passed by an authority, DSDA, which doesn't come under that. An order passed by DSDA, which is a statutory or separate statutory authority. DRT has no jurisdiction over that. DRT cannot.
You
say-
go to the that court where you have filed.
There is a appeal
227
forum is
application.
also there.
227 application, file an application, can there and make an application.
Limited only to the order which we have challenged there.
Exactly.
I cannot expand the scope.
No, you are expanding here. You are saying your interim order you sought for was stay the order of the single judge. There is no order that restrain them from transferring the property to anyone.
Your prayer is twofold. One is stay the operation of this mutation order first.
That is before the writ court.
That is
Writ court has refused that.
That is also before your lord. Unless that particular order is stayed, my lord, further rights will be continuing to be created on the basis of this order, relying on this order. Namely, my lord, the sale deed may be executed, it will be registered. My lord, they may sell it to a third party. All these consequences are, and for each stage, I have to move separate application. Unless this particular order is stayed. Every time, my lord,
So now you are saying that stay the mutation order, that will automatically take care of transferring to third party. Now you are falling back on that. But your argument, if we have understood, on the first day it was that see the sequence of facts, all right, they have taken possession, principles of natural justice violated, you protect me to this extent that let them not sell off the property to somebody else. This was your argument.
That was, my lord, at a stage before your lordship was right. I had made my submissions in a very limited way, which was affecting me straightway. That is what I pointed.
No, we were thinking if you give a second thought to this. However, if you invite us to go into the matter, today a rejection of your appeal may create other consequences against you.
Yes. Whether there is any substance in my substance. When I
We will see that, but Mr. Gupta, we will decide. We will hear you, we will decide. There is no problem.
In the meantime, rights will be created. Because once
what right you are asking?
The first thing is this deed will be executed and registered.
Actually, the issue of maintainability is such a point which is to be addressed by the learned single bench.
Maintainability.
Yes, whether the writ petition will be maintainable or maintainable or not.
Maintainability point, there is nothing else. Maintainability point, when the court passes an order giving direction for filing of affidavits. This shows that the application, that the injunction prayer has been dismissed. There is prayer for injunction.
No, maintainability point has been kept open.
That's the maintainability.
And this issue, maintainability issue has created suspicion as to whether you will get final relief in the petition or not.
Then
create.
Finally, let me address the issue of maintainability. The maintainability aspect, Lord, is
No, Mr. Bihani argued as regards maintainability of this appeal. No, of this appeal.
Of this appeal, yes. Because it does not pass a final order.
No.
Or which has a limited for limited purpose, it is fine. I submit, my lord, that this is wholly erroneous. My lord, the court did not note that the interim order is refused. It has not noted that.
But I have not made my, I'm sorry, I have not made my submission.
Was not that.
I have not made my submission.
The submission was that this present appeal is not made.
Exactly. Why? Because they say,
बोली
man, this
I have not made why.
under clause 15.
Anyway, Mr. Gupta, we wanted you to say that if you can talk with your client and give a second thought to this. However, if you invite us to decide the matter,
Kindly. What is the position of my client now? He is outside. He is not further apprehensive of other rights being created in favor of the highest bidder. In such a situation, Milord, he will definitely be Milord, in such a, even his belongings there, everything Milord is locked up in the house.
No, it's not.
Everything is gone.
That will be the liberty.
Unless your lordship give me a protection. Regarding
Better, Mr. Gupta, you withdrew it and made an application, can one before the writ court. Ask the writ court to apply your mind as to whether interim order should be passed or not.
The case is made out in the writ petition, court did not pass an interim. On what further basis, Milord, I shall make an.
If we pass any order, that will go against you. Hence, we are saying so.
No, but kindly also consider when you lordship, when I move a writ petition and lordship say, so I give only directions. That means, Milord, no interim order is granted by the court. Whether that is specifically.
Now, our consideration is that we can pass interim order only in the situation if we hold that the learned single bench should have passed.
Yes,
But he has committed error.
That is the situation.
But the point of maintainability, which has put a serious question as regards as to whether you will get final relief in the writ petition or not.
What is that?
In that situation,
What
whether
is
it
that? Because there is a provision for appeal. That's the ground Milord of challenging the maintainability of the writ petition.
all right, Mr. Gupta.
Now regarding
Yes, take us to the main matter. Then, Mr. Gupta, let us hear the maintainability point first, then you address us. Yes. You
I
are
was taking the point.
you are for the state.
State.
Achha, tell us what is your maintainability.
Milord, if your lordship sees, Milord, he is aggrieved by the order of the mutations, which is at page 52. Annexure P5.
52. 52 of this
Appeal.
stay application.
Stay.
52 is a prayer.
Yes, prayer of the writ. He is aggrieved by the order passed in the Milord proceedings of the Milord, the mutations. Now, there is a statutory appeal, like in the Land Reforms Act, section 54(1)(a) gives the power to the collector to decide any dispute. So, without Milord skipping over that part, he cannot sought for the judicial review and sought for the Milord the stay of the operation of any order. Simple, Milord. That is, I told you, Lordship.
So mutation pass under section 50.
Land Reforms Act, section 54(1)(a).
54 appeal.
Yes.
Order passed under section 50, according to you.
Right.
Okay.
Well, this is my very short point.
Section 50 is the pass for it.
Yes.
And so far, the other thing is that Milord, the possession, the mutations.
Transfer এর জন্য 50 transfer হলে যে রেকর্ডটা চেঞ্জ
Yes.
Now, so far the maintainability of the writ petition, since I have argued, this has to be addressed first. The maintainability point has to be satisfied first, that he can hurdle up this, he can cross.
That is for the single judge to decide.
Right.
Yes.
That is the order when
that has been kept open. You are not aggrieved by that order.
I have not agreed. I have
very
taken
good.
the
Then
point
what
of maintainability.
your argument is that the writ petition itself is
not maintainable.
So that argument you ought to have made to the single judge.
I have advanced that.
You have made
right.
single judge has said we will consider it is kept open.
Correct.
So now you are stopped from again submitting.
Certainly, Miller, not because
So this argument of yours is a fit argument before the single judge.
Single judge.
Yes. So
single
let us hear as regards maintainability.
Now, my lord, kindly takes the impugned order at page 140. I am for the Diga Shankarpur Development Authority. At page 140, or the impugned order against which my learned senior friends have come up. A very short order. Kindly see paragraph 3. After hearing the submissions made on behalf of all the parties, it appears to me that the instant writ petition cannot be disposed of without granting opportunity to the respondents to file opposition. Therefore, opposition is directed, let the matter appear, point of maintainability kept open. So, my lord, from this order, my lord, there is no reflection whether prayer was made for an interim order and it was refused. At least from the order, there is no reflection. But there are submissions made by my learned senior friend is that since the writ petition contained the prayer for an interim injunction, so therefore it is to be assumed that it was placed before the learned judge. Now, my lord, apropos this, kindly takes the memorandum of appeal filed by my learned friend before your lordship. Kindly takes only one ground of the memorandum of appeal. But kindly takes the memorandum of appeal. Kindly, I'm sorry. Memorandum of appeal filed before your lordships. Only one ground I shall place. Kindly takes ground number 2 at page 4 of the memorandum.
Why you are going on maintainability? Let him argue on merit.
No, I'll bow down to your lordship.
Why do we say, Mr.
Yes.
Biyani, maintainability point? If he is successful before us, writ petition will continue.
Correct.
Writ petition will continue. Maintainability point which is to be argued there, if he cannot satisfy us on the issue of on merit, why we are to cut down the process? Because if you argue full-fledged the maintainability point, we have to return a finding. Now, this finding may lead to further litigation between the parties.
It will.
Subject to
It
what?
will lead to.
It will. So, we are the persons here, we have to decide. But the thing is, you ask me that, no, sir, first decide the maintainability. Mr. Gupta will give his reply. So, extensively, we have to hear on the maintainability. And if I ultimately hold maintainability, then go to the aspect of insurance.
No,
if prima facie he can satisfy us, if he cannot satisfy us, then the matter automatically fails.
Yes, but if you can try to satisfy your lordship, then the maintainability comes in.
No, only you will get a reply to
yes.
that.
Only I'll not place that. I'll only submit on merit, but only kindly sees one line over here. What this? Only one line. Paragraph 2. I'm sorry, ground 2. Only one line.
Yes.
Kindly see the last few lines. It starts with ground 2. The fourth line from the bottom, it starts with prayed for by the petitioners. Ground 2, fourth line from the bottom.
Categorically.
Now
prayed.
kindly says the petitioners have categorically prayed for an interim relief, has specifically pleaded as relief in the said application. Then the same has not been refused, but also has not been considered.
Neither refused nor.
So if it is neither refused nor considered, when in 2023 the Honorable Supreme Court says at best it is postponed. If it is postponed, you cannot file an appeal. I've come with the decision.
You cannot prefer appeal.
If it is not considered, then at best it is postponed for final consideration after the affidavits. If it is postponed, you cannot file an appeal against that. That is Supreme Court says in 2023.
Bhalo point.
Kindly take the decision. This is 2023 1 SCC, page 634.
No, very good. But what is your argument? Whether was it refused or it was postponed?
It was not refused. It was postponed because the case could not be decided without affidavit. So affidavit postponed till the hearing, till the affidavits have been filed.
So that will open a separate arena for him to go and again agitate that.
Before the single bench, yes.
You are agreeable?
No, if he fails on merit, I am not agreeable. If your lordship enters on, because specific submission was made by my learned senior friend.
Reference.
Oh, yes. 2023 1 Supreme Court cases, page 634. I'm handing over to your lordship.
So that was a case where the court adjourned it for 4 days to consider.
No, not 4 days, possibly 3 weeks. Kindly have a look at paragraph 24 to 26.
No direction for appeal.
Yes. No, kindly see paragraph 24. No, kindly see paragraph 24 at page 654. What the learned single judge has done by the said order was to grant 2 weeks' time to the appellant defendants to file affidavit in opposition and postpone the issue of grant of ad interim injunction by 3 weeks. No doubt that the learned single judge has advanced. I'm sorry.
That order by which it was allegedly postponed, that is quoted here.
I'll tell you.
This order?
No, but it says 2 weeks and 3 weeks. No, it even goes further in the next few lines to say, kindly sees, no doubt that the learned single judge has at one place observed that prima facie he was of the view that sham being a part of the business name of the appellant, even no injunction should be passed. So it was recorded that no injunction should be passed. Over here, it is only simplicity affidavits. The Honorable Supreme Court says, even if it is said no injunction should be passed, still only direction for affidavits. So therefore, you cannot come in appeal. Kindly see then. Kindly see paragraph 25. It could thus be seen that the order, in fact, was postponement of the question as to whether the respondent plaintiff was entitled to grant of an ad interim injunction or not, that too by merely 3 weeks. The order was only giving an opportunity to the appellant defendants to file their affidavits within a period of 2 weeks. The order clarified that no prayer for extension shall be entertained. The learned single judge, therefore, postponed the issue with regard to consideration of the prayer of the respondent plaintiff for grant of ad injunction by a period of mere 3 weeks, and that too only in order to afford an opportunity to file an affidavit in opposition. So therefore, over here, no recording has been made in it.
That order in that matter, has it been quoted anywhere in the judgment?
It's not been quoted. It's been set out in paragraph 24, not set out, been stated in paragraph 24, 26 that affidavits filed 3 weeks, but the learned judge had even made a observation with regard to the warrior, no observation.
That was a better case.
That was a better case. I'm deeply obliged. So that is point number 1. Now, if your lord, so that is why I say appeal not maintained. Now, kindly takes the point of merits. I'll only make a submission on merits once because my learned senior friend had placed the order, impugned order in the writ petition. Print out.
And also and consider this consider that
on the basis of
consider the peer predictable.
বলতে হবে ওদেরকে এইটা seeking an integrity. To disturb me.
আমরা পার্টিকে বেঁধে and literally preemptively we will file.
Yes, Mr.
Now, Lord, kindly takes page 48 or 48, 82 of the, there is the impugned order of mutation against which the writ petition is filed. Page 81, I'm sorry, annexure P5. 48 and 82.
Yes, 81.
Lordship. Now, my lord, I will not place it and trouble your lordships. My lord, the submission made, if I am correct, was that there is no change of circumstance after 2021. So it could not be done. Now, my lord, kindly take the next page. It is not serially, it is not very happily worded, but kindly see page 82. First, second, third, fourth paragraph. Starts with whereas in plot number 165. Lordships have got it, my lord. Fourth paragraph starts with whereas in plot number 165. N2 sector, the previous lessee Shubir Das and Gitarani, those are the appellants now, were the defaulters regarding the payment of loan from Bank of Baroda. So when the bank went to take a legal proceeding regarding the recovery of loan through the auction, they filed a case in Debt Recovery Appellants Tribunal in Kolkata through the appeal number 89 of 2022, and the appeal was dismissed. This dismissal is of 30th September 2022. And this is the order. Correct order.
Order is already there.
Where he has annexed. So 30th of September 2022. So this was the change of circumstance pursuant to the orders passed by the UDMA on 2021, 30th of September 2022, after the dismissal of the appeal by the Debt Recovery Appellate Tribunal, which warranted the mutation. So it is not correct, my lord, subject to your lordship's consideration, to say
this appeal was challenging the sale.
Yes, which was dismissed in 2022. So it was subject to correction by your lordship, the submission.
13.4 is still pending.
13.4 is still pending.
13.4 appeal.
From possession, the surface application is still pending before DRT. And
DRT, that is DRT.
DRT.
This is DRT.
DRAT.
the appellate forum, that is the
Now, my lord, DRAT categorically holds in the order that I am of the view that sale notice was published in accordance with law, therefore dismissed. So this was the change of circumstance which warranted the authority, but to revisit and issue the mutation order. So it was not correct, possibly, my lord, subject to your lordship's correction, to say that this order,
There was no change.
there is no change of circumstance, it simply reiterates 2021. So this is
Why
one.
didn't you give them a hearing? You did not give them.
No, I did not give them a hearing on two grounds. One, well, your lordships have categorically held in several numerous occasions.
It's futile.
If it is, I'm deeply obliged. If it is futile, it does not make any sense. That is number one. And number two, my lord, after this, and after the order passed by the order, the recommendation of the UDMA, which is my superior authority, my lord, I have acted in accordance with law.
This was the UDM letter asking to you to mutate
Yes.
in his favor.
Yes.
I have also disclosed that.
No, I have. I'll tell you, it is annexed. It is not annexed here. It was annexed to here. I've got a printout. It was annexed to his writ petition. Oh, লাগিয়েছিস? এটা sorry. এই সবার জিনিস নিয়ে
I wanted to make it comprehensive.
Bosh.
Convenience of
Well, kindly takes page 21st of his notes, because that is the earlier one. Kindly takes page 20. This is dated 8 September 2021. Now the printout আছে না রে?
Yes.
Very well. Well, kindly seized by the additional secretary UDMA to us, apropos to the above cited subject. The subject is lease of plot. I am directed to opine that if the lessor allows the lessee to mortgage the leasehold interest to any bank for fetching money, that in that case it is implied that the lessor is aware that in case of non-payment of installments of mortgage money from the lessor, the bank authority may redeem such mortgage, and that even the leasehold interest in the land may be sold to the purchaser on auction. It is found that there is no order from higher forum staying the proceedings or judgments of the DRT. But the appeal was there. There was no stay, but before DRT, the appeal was there. Hence, the authority, my lord, at that point of did not. Now kindly comes to page 19, which is the letter, reiteration again. This is 30th of September 2021.
Page?
My lord, 19, just the earlier page. 30th of September. Again, the my lord UDMA writes to us, apropos to the above cited subject and reference, I am directed to opine that action may be taken as per the observation of this department, communicated dated 8 September 2021, which is page 20. So it is a reiteration. Now, subsequent to this DRAT order of 30th September 2022, which is the change of circumstance.
Yes.
Well, those are my solutions. I'm deeply.
Yes, Mr.
Page 20, which has just now been referred to. In respect of
yes.
In respect of the document just now cited by my learned friend, page 20, if your lordship reads page 20 of the list of dates, there the Urban Development Department says, upon compliance with all legal formalities, not that you do it straightway. Upon the compliance of all formalities, all legal formalities. The last line at page 20. The last line at page 20, and it was so understood. It was so understood by my lord the DSDA. It was so understood by DSDA while they had passed this order at page 78. They are specifically referred to
So
this.
you have no answer for this, that there was no change in circumstances.
There is, I indicate to your lordship that there was
So
no.
please address us first on that, then you take us. His contention is there is a change of circumstance because the DRT.
When was the change of circumstance?
30th of September 2020.
2022. Kindly come to page 80. 80.
Page 18.
80.
80 to your stay application.
পড়তে পারবে? Page 80.
Yes, 6th of March 24 order.
Therefore, this is subsequent to the order relied on by Learned Tribe. That is of December 2022. He says change of circumstance took place in December 22. And this is an order passed on 6th of March 24 when that change circumstance was already there. Could I
What
make
is
myself?
the order?
6th March 24, again rejecting lot mutation. And after hearing, they say, my lord, it was contended before lordship that they were not heard. See the recording. Today the date was fixed for hearing. Notice were issued upon all concerned parties for hearing. Be it such and such. The case record is put up. Advocate Abhishek Guho appeared on behalf of the Bank of Baroda. Kindly note this. Advocate Somnath Rai appeared on behalf of Sandeep Chakraborty. Advocate Dulal Chandra Sarkar appeared on behalf of the lessee Gitarani. No one was present on behalf of another lessee, Subhit Das. Subhit Das and Gitarani are the same thing. They are both the same lessee in respect of the same list. All the council submitted their respective Bhagalatnama, which were kept on record. After hearing the learned counsel of all stakeholders, it is evident that following all formalities of concerned act, the concerned bank not yet taken over the possession of the property in question. At present, the present lessee Gitarani Das and Subhit Das are in possession on the said plot and operating a hotel thereon, namely Annapurna Plaza. Since neither the bank nor the highest bidder in auction is in the possession of the said property, hence it is ordered that the proposal of the bank in respect of transfer of lease of rights in favor of the highest bidder, Mr. Sandeep Chakraborty, cannot be allowed. This is not subsequent to the change of events, alleged change of events in December 22. On 6th of March, again the mutation application is rejected. And after this, there is no change of situation.
This was following an application for?
Application for mutation.
And 30th September was the confirmation of sale.
Yes. That is in 2022. What they say, the change of situation is this. 2022.
Now, if the appeal had been dismissed on 30th September 2022,
22.
Then this order is passed in which proceeding? Page 80?
Page 80 is in the mutation proceeding. This is passed by the DSDA.
Oh, I see.
This is passed by DSDA allowing, rejecting mutation.
Then when were you sent out of possession?
Possession, after the page 82 order was passed. After the page 82 order allowing the mutation was passed.
So on the date of passing the mutation order, you were in possession?
I'm in possession. I'm in possession. And kindly note this also. No lease deed has yet been registered, executed or registered in favor of the buyer. Therefore, the passing of the property.
But sale certificate has
confirmation
been
is there.
Sale certificate has been issued.
Even after confirmation of sale, one may back out until until the deed is executed. Under considering the provision of the Transfer of Property Act and the Registration Act, the deed of property in respect of a sale is confirmed. The sale, it will go to him.
All right.
He may
Yes.
back out.
What is
But
your
then there
next
has to be a
argument,
registered
Mr.
deed.
TSD is a confirming party that cannot be
If the bank, hands over, even if the bank hands over the property, there has to be a lease deed in which the DSDA is a confirming party, because the original lessor is the DSDA. The property belongs to DSDA. I am the lessee, the first lessee. The subsequent lessee is the new buyer, would be subsequent lessee, provided there is a lease document created. Created means executed with confirmation of DSDA and then registered. Until then, my lord, my leasehold right remains, although the sale is confirmed. Sale is confirmed means you can go ahead with this legal steps.
Yes.
Until then, my lord, a party may back out even. So all these steps, my lord, are still pending. But my lord, we are trying to rely on this order at page 82, that is 82, allowing mutation. My lord, many changes will take place now.
Yeah, is this order at page 82 referred to in the 4th October order of mutation? This 4th October 24 order,
Yes.
anywhere it is been this order?
Nothing. It doesn't say we cancel that or anything. Nothing is that. The order that is 6th of March, page 80 order still remains on record. And page 82 order is passed. I do not know how. It is. I will say it is surreptitiously passed without any notice. The 6th March order.
Respondent के नीचे दे reply दिते है ना?
Yes, Mr.
Third week of March तो हो ही गया.
When is the writ matter returnable?
Writ matter was
Direction for filing affidavit was there middle of November. No affidavit.
No, because the appeal is pending with your lordship.
No affidavit has been filed.
We can file it in 3 days.
Matter was to
Pending.
come up in 3rd week. Nothing.
No,
Your lordships are aware. Is it possible to maintain the dates? Maintain the dates fixed by the.
No, I would have filed it since the appeal was pending. I have not filed.
In a position where there are only 44 honorable judges in place of sanction strength of 72. This is the position in our High Court. Your lordships can my lord take notice of this fact. It is not possible, my lord, even with the utmost effort, for any court, my lord, to take up matters on the dates fixed. This is the position going on for years, and we are all aware of it. It takes years, my lord. It takes years.
Yes. What is your next point? This was one.
My lord, this is the real issue. This is the real issue, that it is passed in violation of natural justice. Secondly, the order is totally unreasoned. On the face of the fact, my lord, that twice it was rejected before. It was rejected twice before. It doesn't, my lord, say on what basis the order is being changed. Doesn't it become functus officio after the mutation application has been disposed of? If yes, he doesn't have jurisdiction. If no, even then, my lord, he has to record reasons why as to why he had earlier dismissed the application for the mutation and why this time it is being granted. No reason is recorded. Reason is the soul of the order. Where is the reason? How can an order, my lord, like this be said to be illegal, a legal order, illegally passed? It is, my lord, not. Now, some party, regarding possession, I am telling, the possession was taken forcefully.
Yes.
After this order at page 82 was passed, we lodged, my lord, FIR to that extent. Several persons, hundreds.
Yes.
Well, that is how, my lord, the position was taken. And on the top floor of this hotel, on the top floor of this hotel, the second lessee, Gita Rani Das, the sister of the petitioner number 1, he with her family used to stay. Well, the manner in which they were driven out.
When was they driven out?
Date 24th October. When we are kindly see this Dana. Entire hotels were in Digha. Entire hotel, all the hotels were directed to be evacuated. They all the borders had to evacuate the hotel. And on that particular day, on 24th at night, this disposition.
Did you lodge any complaint?
Yes.
Show us that. Page
126.
Lord, 126.
22nd date.
Not a part of writ petition, it was by way of supplementary. It is part of the filed on the day of hearing.
Writ petition কবে হবে?
22nd.
Writ petition was affirmed on 22nd. How could it be part of the writ petition?
22nd?
22nd
October.
It was I mean affirmed on 22nd October.
Then you were in possession.
I am in possession then. How could I, my lord, anticipate that this will happen? My learned friend says it was not mentioned in the writ petition. How could it be? It's a fact subsequent to the filing of the writ petition.
After getting a copy of the
writ petition and taking the advantage of this Dana, this natural calamity, they have taken.
Jana?
Dana means the natural calamity, the cyclone.
Oh, achha, sorry.
My lord, the Digha administration directed all the hotels to ask the boarders to leave, and all hotels were evacuated.
Have you written that in your complaint? Where do we find that fact?
My lord, this complaint is on a printed form, first information report.
Page
26.
26?
Yes.
126.
Yes, 126.
126?
Yes, 126. That is the FIR. My lord, if your lordship kindly, that is the FIR in the form, kindly come to 130.
128টা দেখো বাবু ইংলিশে লেখা আছে
আজটা যে সাইক্লোনের জন্য তাহলে এইরকম মোবাইলে
Kindly come to page 130. This is my complaint on the basis of which FIR was recorded. Page 130 is the complaint. আমার আপনার নিকট বিনীত নিবেদন এটসেট্রা আপনার থানার অন্তর্গত হোটেল অন্নপূর্ণা প্লাজা নাম্বার 7 আমরা এই হোটেলটিতে অত্যন্ত সুনামের সাথে ব্যবসা করতাম এবং এরই ওপরে পরিবারের সবাই মিলে থাকতাম। আমাদের পরিবারের মধ্যেই হোটেল অংশীদারের একজন আমাদের খাদার গোবরা প্রাথমিক বিদ্যালয়ের শিক্ষিকা হিসেবে কর্মরত।
All right. Now, Mr. Gupta, what is your reply to their maintainability argument and this postpone?
Yes, the maintainability argument is this, my lord.
Your argument, natural justice violation, no
reason,
change of circumstances,
and no reason in the order.
There was no change in circumstances and there is no reason in the order.
Yes.
Very good. And what is your reply to the maintainability point and
The maintainability point, my learned friend says that citing this Sham Steel. I have read that document. Because from that judgment, my lord, your lordship will find that the court court proceeds on the basis that the prayer for interim order will be considered after 3 weeks. That's the reason, my lord, why the court said that why wait for 3 weeks. The question here is, in the present case, my lord, is it not just it is just not a prima facie case. It is a much stronger one, where, my lord, I need an interim order immediately for protection of my right, so that my right in the main matter may subsist. It is, my lord, something, my lord, the facts in the Supreme Court case is not, my lord, such, my lord, that where an interim order was absolutely necessary to be passed immediately. My lord, there is what is called ad interim order, even without hearing other side. Your lordships are sometimes my lord, your lordships are entitled to pass orders where the danger is imminent.
When was the writ petition filed, you said?
22nd October, during the vacation.
And you were dispossessed on 24th October.
24th October.
When did you file the supplementary affidavit?
On 28th. On 28th.
So this was before the vacation means? This order was vacation? Oh.
Status quo. 90
মানে এটা করবি সমস্ত ডিকটটা son of the shield of the shield.
Your lordship gone through this page 130. Page 130. Page 130, my lord, my complaint to the police.
Yes, that you have seen.
Your lordship have read that. You know, this is how, my lord, the position was taken after they got this notice of moving the writ petition.
And on the point of maintainability?
You know, I am coming to that. Just before that, my lord, on the aspect of an interim order, whether our case can be fitted in the jacket of the sham steel. My lord, we are, my lord, we had. কোথায় এতগুলো কেন? একটা প্যারা ম্যাচটা করা
আচ্ছা কাকু তুমি বলার আগে একটা প্যারা প্লেস করে দিলে তোমার রিপ্লাই দিতে সুবিধা আমি মিস করে গেছি বাট আই এম সরি বাট ইফ I have missed out one paragraph so that my learned senior friend can address that also in that same judgment. Kindly see, I refer to paragraphs 24 to 26. I have failed to my mistake place paragraph 26. Kindly have a look at paragraph 26 so my learned Sam is my mistake so that he can reply to it. Kindly see paragraph 26 once. It is thus clear that there was no adjudication with regard to the rights of the respondent plaintiffs to get an ad interim injunction during the pendency of the suit. Though by postponement of the issue with regard to the grant of ad interim injunction, the order might have caused some inconvenience.
Yeah, just a moment.
I'm sorry.
Page 20.
Paragraph 26, my lord. This is at page 654. If my lord, I have referred to 24 to 26, but not have failed to replace 26.
Yes.
It is thus clear that there was no adjudication with regard to the right of the respondent plaintiffs to get an ad interim injunction during the pendency of the suit. Though by postponement of the issue with regard to the grant of ad interim injunction, the order might have caused some inconvenience and maybe to some extent prejudice to the respondent plaintiff, the same could not be treated as judgment, inasmuch there is no conclusive finding as to whether the respondent plaintiff was entitled for grant of an ad interim injunction or not. As such, the order passed by the learned single judge did not contain the traits and trappings of final.
Gyani, you are agreeable that if we record this?
No. Well, since my learned friend is referring to
No,
this.
that to make this observation that there was no conclusive finding of the single judge.
I'm sitting down.
As regards the entitlement of
No.
As regards the entitlement of adding.
The last submission, lordships will ignore.
So, Mr. Gupta, if you ask and fix a mandatory preemptory period that within such and such period they will exchange their affidavit and the learned court will
You know, nothing can happen. Kindly see the practical scenario. As I said, our sanction strength is 72.
Mr. Nag,
The honorable judges, my lord, are working overworking.
We are embarrassing you though.
learned single judge.
Though we are embarrassing you.
My lord, in the meantime, entire
In the
prejudice.
meantime, no third party interest will be created. No. You will sell.
I tell your lordship, he has no right. I will refer to latest judgment of Supreme Court. He absolutely what has fallen from your lordship during this year.
And only to avoid further litigation, further complication, further litigation.
It will come if he has not a 0.1% right. He has lost his right. His right is extinguished. He is a trespasser in respect of the property.
In spite of the
judgment before your lordship. What has fallen from your
in spite of pendency of the proceeding.
one paragraph you will lordship. He concludes.
Let him finish. Yes, Mr.
Proceeding is pending still now. It's not the final adjudication as yet. Now, if your lordships do not grant it today, what will the consequence? Your lordship has seen 22nd October writ petition is served, 24th they take steps. They act so fast, my lord, when they see that that court may intervene. Court may intervene, therefore before that ruin their case. This is a case, my lord, where an immediate order is absolutely necessary. My lord, I beg to place, my lord, one judgment.
এখানে 14 বার হয়েছে বুধবার
Yes, Mr.
Your lordship will kindly take this 1990 judgment. What consideration should weigh in your lordship's mind in considering the prayer for interim order in such situation? I shall.
90 volume 2.
Yes, 1990 volume 2 Supreme Court cases, page 117. Page 11. Yes, 117. I am referring to paragraph 16 of this judgment.
Page 117.
117. It starts at, yes, my lord, at paragraph 16. Turab Kawasji. Paragraph 16. The relief of interlocutory mandatory injunctions are thus granted generally to preserve or restore the status quo of the last contested status which preceded the pending controversy until the final hearing, when full relief may be granted, or to compel the undoing of those acts that have been illegally done, or the restoration of that which was wrongfully taken from the party complaining. But since the granting of such an injunction to a party who fails or would fail to establish his right at the trial may cause great injustice or irreparable harm to the party against whom it was granted, or alternatively not granting of it to a party who succeeds or would succeed may equally cause great injustice or irreparable harm, courts have evolved certain guidelines. Generally stated, these guidelines are weighing the balance. The plaintiff has a strong case for trial, that is, it shall be of a higher standard than a prima facie case that is normally required for a prohibited injunction. Two, it is therefore it has to be not only a strong not only a prima facie case, but also must be stronger than that. Secondly, it is necessary to prevent irreparable or serious injury, which normally cannot be compensated in terms of money. Three, the balance of convenience is in favor of the one seeking such relief. Well, in our case, our right is still sub judice. Right is still sub judice. Irrespective of the fact that there has been confirmation of self, the right is still sub judice. The entire gamut of proceedings, entire gamut of requirements of law for the passing of the title has not yet taken place. And in any event, it is subject to pending proceeding.
Right is still subject.
Where is that line? Right is still sub judice. In support of your contention that it is still sub judice.
Yes, yes.
Which paragraph?
No, not in judgment. I say in my case, my right is still sub judice. It is pending in the High Court. It's not that the DRAT is the final authority in our country. It's not that. Confirmation of self, even my lord, the person who is the highest bidder may back out from the transaction. Lots of cases it happens. Therefore, today, my lord, if my
So you are wanting to ensure that no third party right is created in the meantime.
But not only third party right. Why, my lord, allow them to have a lease or title in their favor pending the litigation?
That is a bit far-fetched, Mr. Gupta.
Why, my lord? Kindly see where. If I have a case stronger than mere prima facie case, then a mandatory injunction.
You are admittedly a defaulter. You are admittedly
defaulter. I am admittedly defaulter.
You are the indisputed facts you must admit.
No,
that
not
you are
disputed.
admittedly a defaulter
Facts are
from
not disputed.
No, it is continuing since 2019.
I am,
Surface notice was
not a case
19.
of disputed question of
Here
fact.
is 2024.
Yes, it is not a disputed question of fact. I say the facts are rightly placed by all sides.
Yes,
The
you
facts are
you can say so much that yes, you there was no change in circumstances. Still, you abruptly passed the order without hearing.
Therefore,
Limited to that point.
therefore, that order, can that order ultimately stand the test of judicial scrutiny?
Why not, Mr.
Because-
Gupta?
because it is-
even if you are granted a hearing, what will you say to the DSDA?
Lordship,
Even if you are granted a hearing, what you will say to the DSDA that I am not a defaulter?
my lord, what I am contending before your lordship, what is the change of circumstance? Where is the change of situation?
That is why they will hear.
Where did you?
Justice indicating doctrine of prejudice.
Doctrine
How
of-
we will prejudice.
The prejudice, exactly. Prejudice, my lord, that in the middle, the Supreme Court judgment was that not only violation of natural justice, but prejudice has to be shown. Subsequently, Supreme Court has deviated. Not in all cases prejudice is required to be shown. And prejudice, my lord, is writ large here. Prejudice is writ large. My right with regard to this property is still pending. Is still pending before the court. And my lord, we may succeed. If one cannot presume, my lord, that we will end up in losing the battle.
We can keep the whole money
Very good.
due as
And what about maintainability? What is your argument?
Yes. Now, before maintainability, I cite another judgment on this. This is 2010. No, this is 2010, volume 6. SCC 193. 193. I'll refer to only one paragraph. This is Eureka Forbes case.
Yes.
when we succeed in here, you're right.
Paragraph
66. 66.
66.
Yes. My lord, the default had arisen during the COVID period. Default had arisen during the COVID period. Even today, my lord, we are
Default arisen in 2019.
no, but during the COVID period, we approached the bank, my lord, for a settlement. In any event, even today we are ready to pay to clear the dues of the bank.
Then why did you invite this trouble?
No, because as I said, my lord, because the COVID period, my lord, there was no tourist. We had suffered, my lord, loss for about 3 years. Total loss during that period, during the COVID period. Otherwise, prior to that, we had been making regular payments.
All right, para 66.
66.
Yes.
The maxim, nullas commodum, capar, etc., has a clear mandate of law that a person who by manipulation of a process frustrates the legal rights of others. Here, my lord, I want the illegal taking over a possession. Should not be permitted to take advantage of his wrong or manipulations. In the present case, respondents 2 and 3 and the appellant have acted together while disposing of the hypothecated goods, and now they cannot be permitted to turn back to argue that since the goods have been sold, liability cannot be fastened upon respondents 2 and 3, and in any case on the appellant. The bench of this court in Ashok Kapil versus Sanaullah referred to rule of mischief, and while explaining the word building, held as under. The question is, the principle is, the wrongdoer must not be allowed to reap the benefit of his wrong. That's the principle. Nullas commodum, etc. My lord, your lordships have seen in how my lord, they have done this.
Yes.
Your lordships have seen how fast they can move. 22nd, they receive the notice, 24th, they maintain the damage is done. Now, what is about the what is the point regarding maintainability in view of the sum skill judgment? That's the basis of this submission. Now, my lord, the question here is, here it is a case where an immediate protection is necessary from the court. Your lordships have seen without protection what happens.
The maintainability of this appeal.
Maintainability, I am on that. The question is that the court has, whether court has passed, court did not pass an interim order of injunction. Therefore, there is no adjudication even at the interim stage. That therefore appeal is not maintained. That's the submission. But my position before you, but my stand before your lordship is that we have brought before the court the entire factual situation, which definitely called for an order order granting protection, even for a limited period. My lord, the absence of such protection, my lord, leads to to further damage being caused. Not only further damage, it may destroy my right also. Therefore, the principle of Order 39, Rule 1 and 2 is squarely applicable here to protect, my lord, the property and the rights in the same position for the purpose of final adjudication. That's the, my lord, principle, the first principle of granting an interim order in injunction. The rights have to be protected first. Otherwise, where from do I fight? I will be in the deep sea unless my right is protected today. My lord, I have to go on fighting litigation one after the other. There will be change in the third party interest created, lease deed executed. I have to file. I have to file. I have to file declaration suit.
That interim order has not been paid for before the
No, interim order has been paid for.
particulation. You have changed a note to take
Milord, when the court does not pass an
any
interim order,
steps or further steps on the based on the order dated 4th October 2020.
Milord, your lordship,
It was not fair.
Milord, your lordships, hands are not tied.
No, Mr. Gupta, what is your reply to that? There was no adjudication. So the point has not been finally decided.
The question is, no, when the case is placed before the court, it was the duty of the court to adjudicate. For the for the reason of fault on the part of the court, should a litigant suffer, the fault is that, Milord, a case is made out for grant of an interim order, for grant of an immediate protection. If the court fails there, the division bench is here. I can come before your lordships.
Yes. All right, Mr. Gupta. Yes, Mr. Man.
No, my lord, I am just going to place 2-3 documents before your lordship. I will not take much.
Yes.
Now, lordship, kindly come to page 8 of my instructions.
Page 8.
Now, this is
Thank you. কেন কেন না না ওখান থেকে তো বলছি এখন না না এটা লিস্ট ও কি একটা ফাইল করে
no objection of my list of this. No objection certificate given by DST at the time of taking loan. Now he is saying that violation of natural justice and all. Let kindly have a look at the last paragraph. Or the first, this office has no objection to create charge on the leasehold interest over plot number such and such for construction of hotel building in the above plot on the condition that will not make any responsibility in matter of repayment of loan. PSDA will not take any responsibility. Soon after execution, the certified copy of the mortgage shall be furnished. Provided further, this is very important, that in case of taking any action against the above said liens for realization of dues, the concerned bank financial institution should ensure that the new holder of the leasehold interest become assignee of the above pension loan of the base period of lease and pay necessary fees. What right if he has defaulted and in consequence thereof a sale has taken place? Can DSTA even say no? Because he has given no objection certificate at the instance of Mr. Gupta's client. So this is the position. Now, when it kindly come to the first order in the stay application, page 79. I am just placing the important thing. So if DST has given no objection certificate, say duty bound to give mutation and transfer the leasehold right to me. This is their document. You cannot decide from this. Now, page 79 of the stay application. And it is the
No,
first
Mr.
It
Nag.
was created in favor of Subir Das and Sagas Das. Subir Das.
The appellant.
Appellate, yes.
Subir and Gita.
Sudhir Das and Gita Rani Das, they are the appellants. Now, my lord, page 79, the first rejection order.
So, Mr. Nag, if you say that you are intending to occupy the property and do some business there, that is one aspect of it. But if you are intending to say, now I have got the property, I will give it to somebody else. We are good, bad, indifferently, your respective arguments needs to be dealt with by us. Today, we usually in read court, what do you say? That Mr. Nag, are you intending to do this since the matter is sub judice? Can you stay your hands for that effect, or whether our order to that effect would be causing an irreparable loss to you? Now, one thing is the sequence of facts needs to be taken into consideration. You are right. He has no right, no semblance of right, because he had been a defaulter and that has been confirmed by the appropriate statutory authority. Lease deed, sale certificate is there. I am having as good as a title in the property. We understand that. But when a matter is brought to the court, you have done thousands of matters wherein you see you try to modulate your prayer. That all right, if I do not get that much, all right, give me this much. Or at least give me my right will be subject to the result of the writ petition. That is the worst type of state. So
what
we are
you have got to create sublease,
No, nothing.
to assign in property to anyone for
I would have, my lord,
no, Mr. Nag, we are not taking any concession from it. Please do not. We are wanting to know the actual state of affairs. Is it the affair that it cannot wait for 1 month? Because 1 month, let there be an adjudication and finish it off. We can, if you have a serious instruction to this effect, that no, I have done this, I have got it today. There is no bar on my part to give it to somebody else.
the agony of my client is paramount, because from that 2020, he has paid 3.5 crore and he could not even utilize the property till he got a petition. This is the situation of my client. I could have happily, my lord, acceded to shares of your lordship, to the what has fallen from you. But the situation is such: 3.5 crore paid, could not utilize, and a person who has not paid a single penny is my lord, resisting it like anything. My lord, I will place just 2, 3. I will not.
Yes.
Lordship, now that we come to page 79 of the of the stay application, and one line, I am just going to place Lordship has seen the fact only the relevant. Page 79, Lordship will find the last line of the order, as your Lordship
Yes.
cannot be considered at this stage by the undersigned. The last line. Now, as neither bidder possession, there was a dispute in respect of possession, it always was. Mutating leasehold right interest in favor of the highest bidder and such and such cannot be considered at this stage. So it is not a refusal which cannot be changed. That was his argument, but it's not that. Number one. Number two, there is no procedure in law which states that there has to be a hearing given, or anything has to be heard, or a natural justice should follow. He is supporting this order. In this order, no hearing was given, nothing was called, but he is supporting that. But is against the last
This order also. No hearing was.
Hearing called. No documents not for. Take my word, I am on instruction submitting before your lordship. So if in first case, first order he supports.
First order is page 78. 78. When is the next mutation order?
Next mutation.
Rejection?
They say
rejection was twice earlier, na?
Correct.
One is page 78.
78.
Other is?
Page 80.
Page 80 is the one which is challenging.
Another.
Oh,
Another.
oh, achha, page 80, yes.
Concocted order, because we never received it. I never received a copy of this order. I also with instruction. And also this is the copy given to us. Lordship can see, I can't read anything. of this order. This is the copy given to us.
Yes.
Now, my lord, so this order was never given to us. So my point is very specific. If he supports an order where no hearing was given, there is no procedure, statutory procedure saying that hearing has to be given, then he cannot just resign from his stand when he lost it. The national point of natural justice just cannot propped up when he loses it. When he wins, okay, it's fair not to give natural justice. So all the materials were before the authority. And mutation office never become functions of. Now, my lord, these are the, then, my lord, in the impugned order before the deed.
Now, in the section 14 proceedings, what happened? They did, you must have applied for
pending, I mean.
Twice rejected. That is why. While the section 14 proceeding dismissed, then they, at that point of time, they transferred. And may I just point it to the subsequent purchaser purchased it knowing that there was no physical possession. He cannot now shout saying that physical possession should be given. He purchased it at his risk at that point of time.
Now, my lord,
These are speculative buyers who buy it at a lower price.
I have not objected, I have not interrupted him. Now, lordship, one thing, when they are well, when this order was passed, which is included before this read, well, here was a change of circumstances. I demonstrated that. Mr. Biani demonstrated that records the order passed. So this order taken into, and that was the change circumstances and this order. Well, these are the facts. These are the facts. I say, well, they cannot claim any right because they have lost their habitual effort. Now, man, kindly, I have given 3 judgments and an extensive list of this. I will just quickly take your lordship to that and the point of law. Now, man, kindly come to page 35. This is the first judgment. 2002. Volume 4, this is 638. Now, here, paragraph 17, I am placing before your lordship. If there is no right, the mandamus can be given. Paragraph 30.
Para 30.
Paragraph 17 at page 55. Well, that's just your lordship. Can you come to page 55? Coming to the third. Coming to the third question, which is more important from the point of consideration of the High Courts for issuance of mandamus, it appears the Constitution empowers the High Court to issue writs, direction orders, nature of habeas corpus, mandamus, prohibition, warranto, certiorari, and the enforcement of the rights conferred Part 3 and for other purpose under Article 26 of the Constitution. It is therefore essential a power upon High Court for issuance of high prerogative writs for enforcement of fundamental rights as well as non-fundamental and ordinary legal rights which may come with the expansion of it. The power of High Courts under Article 226, though are discretionary and no limits can be placed upon the discretion, they must exercise along the recognized lines of subjects self-imposed limitation. The expression of any other purpose in the article will make jurisdiction such and such. Then excessive power issuance of mandamus, the court must come to a conclusion that aggrieved person has a legal right which entitles him to any of the rights and such rights may be infringed. So there has to be some kind of right. Next judgment at page 58. So 3 judges bench, very recent judgment reported in 2024, volume 6, 579. And exactly that what has fallen from your lordship during this hearing. Kindly come to paragraph 32. Just one paragraph, page 67. Exactly that was has fallen from your lordship.
Yes.
It is thus clearly seen that though it is specifically contended on behalf of the appellant, herein the writ petition was not maintainable on account of availability of alternative remedy, that is before DRT. The High Court has interfered with the writ petition only on the ground that the matter was pending for some time before it, and if petition was not entertained, the borrower would have left limitless. We, however, find that the High Court has failed to take into consideration the conduct of the borrower. It is further to be noted that though the High Court has specifically informed that on account of subsequent developments, that is confirmation of sale and registration thereof, the position has reached at irreversible stage. It's like my case. Irreversible stage. It can only be reversed by the article under the petition under Article 227. Before that, he cannot even say. His Supreme Court says the right has been irreversible stage. The High Court has failed to take into consideration those aspects of the matter. So that what has fallen from your lordship during hearing. Now, and 227 never been moved till date.
Irreversible stage in your favor.
My favor. Also, my lord, I will say.
So what you are trying to say by this paragraph?
By this paragraph, I say that now he is a trespasser. The right is in my favor. He has no right. So he cannot even seek any remedy. And
his right is sub judice, Mr. Nag.
My lord, today 227 is came. He not even moved for last 2 years. My lord, there can be 1,000 cases like that. But that does not give him a right. And the right, he said, my lord, I will also rely on a judgment of the Bafna Motors, which says that if a sale is confirmed, if a sale notice is given, the borrower loses his right for redemption. The right of redemption of the property, that's what Mr. to say. He has not even right of redemption. That's what the Supreme Court said. I will also place the judgment for your lordship. Now, my lord, so this is an irreversible stage, and he cannot.
Yes.
Now, my lord, next, lordship will see. This is a trace. Well, today I said that he is now, as he has no right, he can be said as trespasser. And the trespasser cannot have any right over a property or can seek any relief. Well, the division bench judgment of Bombay High Court at page 70, lordship will find 2009 SCC online, Bombay 236. 2000? 2000, I have given page 70. Page 70, lordship. Page 70. Well, not one paragraph. Para 7 and 8. After the petitioner was dispossessed, the petitioner forcibly entered property of such and claimed by the respondent. The petitioner would still remain a rank trespasser and would have no right in the property in question. Even from the point of view, the petitioner having no interest in the property except trespassing cannot be protected by this court in exercise of writ jurisdiction. Though the observation may have no strict application to the facts and circumstances of it, needs to be noticed that Supreme Court in the case of such and such took a view that a rank trespasser is not entitled to protection of law and could even be dispossessed. So he cannot say. Now, what is the relief he has?
Pardon?
He is already agitating his dispossession.
Yes.
Now the only right he has is to file a suit under section 6 of the specific
That is another right. All right. Yes.
So read court should not interfere also in
That you have showed us 3 judgments. Read court should not.
73. Well, 73 is the judgment on the proposition. It's a mixed question of fact, and in such cases, well, 12, 13, and 14. No, 10, 12, 13. It is not in dispute. The release of the petition was filed by the respondent pertain to possession of the flat. It is also not dispute. One civil suit between such and such, such and such, such and such. Now 12, the question as to who is the owner of the property, possession of the flat, so from which date, how, what circumstances.
All right, Mr.
One judgment, he said, he has some kind of right. Placing 2010 6 SCC 193.
In 3 SCC.
10 6 SCC 193.
Para 66.
Para 66.
No, that is 10. We have
now, apropos to this,
the 10 6 is sorry, sir.
In response to this, this is the judgment.
COVID time. COVID intervened.
Now, if Supreme Court in this judgment reported in 2024, volume 2, SCC, page 1, Lordship sees the
2024,
volume 2, SCC, page 1. Now, kindly see the conclusion portion. I already obtained a copy from the file. The conclusion portion from 100 onwards says, if a sale is confirmed, the right extinguishes. He cannot seek for redemption. Issue of sale notice. Mutation is a further chapter.
English listed the bottom of date of publication and not pre-publication of this.
To reading. I will hand over a copy after this one. Yes. So today, from when the sale notice is given,
100.5. रोज बड़े सिद्ध
one line, when a lordship has seen from the contract. From 2019 onwards, he has not paid a single.
Yes, we have.
He is not entitled to any equitable.
Yes.
My lord, will hear me for 2 minutes, my lord.
Yes.
For the bank.
You are for bank?
Yes, my lord.
Yes.
But first and foremost, my lord, since everyone has made elaborate submission, my lord, I will not make much elaborate submission. 2-3 points. My lord, first and foremost, the no objection certificate that has been relied by my learned friend in the list of dates, it's there in this thing also. My lord, first and foremost, had DSDA not granted this no objection, the question of granting the loan does not and could not have arisen. My lord, kindly see the no objection. At the end, it has been addressed to the bank. Now, my lord, once this loan was granted and DSDA gave the permission for mortgaging this particular property, the mortgaging the leasehold right with the bank, my lord, at that point of time, the borrower loses the right till the time he does not repay and release his mortgage. So the question that my learned senior friend is agitating, that his right perhaps was not there till the time he does not repay the amount. The moment the NOC was issued, right was given to me as a security and it was kept as a mortgage till you pay my loan. If you can't pay my loan, I have the right to enforce it. Now that enforcement comes under SARFAESI. Now SARFAESI Act says that if someone fails, you issue a notice under 13.2, and thereafter, if the person does not pay off the money within 60 days, you issue the notice under 13.4. Now 13.4 is an action for taking possession. Now 13.4 has several bifurcations. One is taking symbolic possession. Now, my lord, my learned senior friend is saying that TRT application is pending. In 13.4, there were several properties. This is one of such property. 13.4 was 13.2, 13.4 was challenged, section 17 application pending. Out of the several properties, one property was put up for auction.
There are, apart from this, there are other properties.
There are other
Of the
properties.
same person,
Of the same person.
not of the same person.
না, আরেকটা property আছে গো। না, 13.4 is only property.
Where from you are getting that? Yes.
Huh?
Yes.
My lord, I'll just confirm that with that. Now the SARFAESI application 13.4 is pending. Now post 13.4, bank has issued the sale notice. My learned senior friend's client has challenged the sale under ABC reasons. Now that challenge failed. They went up for DRAT, failed. They preferred High Court. Now, my lord, today kindly see the prayer in the writ petition. That prayer was not shown. My lord, kindly see page 52 once. I'll try to be as quick as possible. Kindly see page 52 of this stay application.
Yes.
Page 52, paragraph B. My lord, in the middle portion, is seeking for a quashing. An order dated 4th of October 2024 issued by respondent number 3 and any other orders or decision to allow mutation. My lord, my respectful submission is, once I sell the property and issue the sale certificate, my lord, once I issue the sale certificate, sale stands complete. But my obligation does not stands completed, because that is what Rule 9.7 says. May I just...
Very good, sir. That are the regards of the SARFAESI Act. We understand.
Exactly. Now, when he is challenging the mutation, my point is, when he is challenging the mutation, that is also a step that I have taken under Rule 9.7, and it is coming within the periphery of SARFAESI Act, which he cannot challenge by way of a writ petition. Kindly see Rule 9.7 once.
Yes, yes, till you will remain secured creditor.
Creditor, and
even after issuance of certificate of sale.
Certificate,
Yes.
and it is the
To complete your next formality.
Exactly. Now the duty...
Now you have got the money.
In spite of getting the money will not absolve
No,
me
now
from
you
my
have got,
liability.
now you have
I have to
already
make it
got
income
3.5
free.
crores. You have got 3.5 crores
Yes,
now.
yes, yes. I have got that. But
yes,
action that I have taken,
Ashok,
consequence
yes,
of which is the mutation.
learned advocates appearing for the respective parties have concluded their arguments. Please the matter as for orders. As fixed on such and such on calculate data as fixed at 1 p.m. We will pass our orders on. We will pass our orders tomorrow.
May I make one statement, one sentence?
Yes, Mr.
Just once. Milord, page 67 of in his list of dates, he has referred to a judgment which is at page 67. The relevant paragraph at page 67, paragraph 32.
Pardon,
Page 67, 67, paragraph 32.
32.
Kindly come to the bottom of that paragraph. That is confirmation of sale and registration thereof. Not only confirmation of sale,
Not only confirmation but registration.
Followed by registration. Therefore, when registration is done, then my right. I say that the stays further to mutation. Unless some protection is given, the registration will come down. Once it is registered, I'll be in a soup. Once the deed is executed in favor of the respondent number 5 and it is registered, then my right.
He lost his bus even to pay.
There
is a judge, there are also judgment that registration of
Exactly, my lord. Sakina.
Formality.
The Sakina judgment by
not only
Honorable Supreme Court, which says sale
Execution.
certificate does not require.
There has to be an execution of a document.
Not necessary at all.
It is a Madras High Court judgment, Mr.
Even
Supreme
Court, my lord, Sakina.
Sakina judgment, which says
Sakina.
Sakina.
Yes.
That
Sale certificate is as good as a title.
Exactly, does not require registration even. That what my learned senior friend is.
Hand over to the judgment.
All right.
My learned
Yes.
senior friend is submitting
Hey,
is that
Shunu.
this deed has not been registered. Sale certificate is good
retain
enough.
your books, huh?
Lordship,
Retain your
there
books.
is a contrary judgment to be posted.
এই বইটা তোকে বললাম বই তো আমার
No, no, আমার বাড়ির চারটে।
হ্যাঁ আমারও দুটো আছে
Lordship, to two judgments we have to hand it over to your lordship. One is BAFTA
না না
and another is Sakina.
You have not given the.
No, you don't
photocopy
have.
of
Yes,
this
I am
judgment,
giving that to the
and
court
you have
officer.
not given the photocopy of this judgment.
but
Ballot, give that book.
within
Ballot,
10 minutes I'll make a print out
within 10 minutes. Ballot, kindly give the books. I will give copies to
বই
you.
I don't need the books I've got it here I'll give a
No,
print out to you
that
আমাকে
we,
ছোটটা
Mr.
বইটা-
Biyani, you keep it. If we have the Xerox, there is no
No,
reason.
no, I will do that.
no I don't have
hand it over.
given a lordship the photocopy I've given the lordship the books so I'll make 2 photocopies and hand it to your lordship
Okay,
lordship
okay.
এটা একটু
And
print
if
out
it
কর।
can be done at by 3 o'clock, if you can.
But I'll give it by 1:30
After that, you will see the result tomorrow. Grateful to you.
মেল পাঠিয়ে
সুব্রত কোথায়? কখন ওঠে কখন বেরোয় যায়?
Well, can you remember this matter?
Yes.
Initially, your lordship has heard this matter. But the point involved in this case.
When did we last hear?
Last, your lordship heard this matter on.
All right, tell us first. Hey, it was for you, not paper. আমি বুঝি না এসে মাত্র চলে যায়
6th of November.
Yes.
We preferred this appeal, but only being aggrieved by only one point, which was held by the learned, not the single judge. Your lordship will get that reference in page 120, 120. Now, all other point went in my favor, but only one point, we could not succeed, and court ultimately hold this is a the violation of principle of natural justice. Kindly see 120, where the court has summarized the point which was involved in this case, and all the, except one point, all the point went in my favor. 120, my lord.
Yes.
Whether the commandant issuing the charge sheet could have held
Page
the
120.
120.
Yes, yes.
Internal page 8. Whether the commandant issuing the charge sheet could have been held the summary security force court or not, my lord. My lord, may I read, my lord, further? It is true that commandant of a unit of the force may hold a summary security force court. However, it is tried law that the person who had inquired into the charges or issued a charge sheet cannot sit trial over the same. But this is the finding of the court. First, the such person who have been interested in the success of the charge sheet. Secondly, if he had inquired into the charges, then he had been the shoes of a witness. In the earlier event, such a person cannot be adjudicated the case proposed delinquent of the own charge sheet. The procedure that would be so unreasonable that a chance of prejudice will be deeply ingredient in it. The sufferer need not be proved the prejudice separately. It has thing is permitted the whole efforts of the administration of justice vis-a-vis the principle of natural justice would crumble. But this was the finding of the court. The court of the opinion was of the opinion, Lord, the person, the commandant who has issued the charge sheet, the same person can hold the SSFC court or not.
Cannot hold.
Whether they can hold or not. This is the moot question.
Okay.
Yes. In other question, your lordship will find the right of hearing, the brief taking of brief needs to be proved or not. The finding of guilt, it went in my favor. All these issues went in my favor. So, my lord, today before your lordship's court, only consideration is this, my lord, whether the commandant can play the dual role.
Take us to the rules once.
Yes, my lord, one by one, my lord, I shall take your lordship.
Yes, please.
First, my lord, kindly turn to the BSF Act, the definition, section 4. My lord knows the BSF is a, my lord, disciplined force. 4. Constitution of force.
Yes.
Constitution of force, subclause 1. There shall be an armed force of the Union called by Border Security Force for ensuring the security of the borders of India. My lord got it?
4. Yes.
Now, my lord, kindly come to few definitions which will be relevant, my lord, for adjudicate in our case. Those are, your lordship will find 2B, section 2B, battalion.
Yes.
Battalion means a unit of the force constituted as a battalion by the central government. So it's a unit of a force. My lord, got it?
Yes, unit of the force.
Yes. Then, my lord, kindly turn to section 2F.
Section 2F.
2F, commandant. My lord, this is very relevant for our purposes. My lord, the commandant, when used any provision of this act with reference to any unit of the force, means the officer whose duty it is under the rules to discharge with respect to that unit only. So any unit means, my lord, in the statute, it my lord, restricted to that unit only.
Of which he is commandant.
Yes. Of that unit, the functions of the commandant is regard to the matter of description referred in the provision. So any unit of the commandant means the commandant of that unit only.
So battalion is the unit of the force.
Unit of the force.
And commandant when
Is
you
the
say
head of the battalion.
any unit of the force.
Yes.
So
Unit.
that
So
force,
head of the
that
unit. Head of the unit. In that unit only. Now, my lord, kindly turn to 2U, Security Force Code.
Yes.
My lord, 2U Security Force Code means a code referred to section 64. My lord, got it? Now kindly turn to page 64, section 64. There are 3 types of security code, my lord.
Section
64, chapter 6.
Yes.
Kinds of security force codes. For the purpose of this act, there shall be 3 kind of security force code, that is to say, A, general security force codes, petty security force code, and summary security force code. My lord, in present case, my lord, the respondent is aggrieved by the proceeding initiated by the summary security force codes, where he has been dismissed from service.
Yes.
Now your lordship will get that section 65, 66 and 67.
Yes.
68 and 69. Well, important is 68, 69 and 70. Composition of security force code. Well, although this is not relevant for the purpose of the in our case, but still your lordship can get it from here, that how a security force, general security force code, petty security force code and summary security force code functions.
Where is this 70? So relevant
Yes,
is
relevant is 70.
So read that.
Yes. A summary security force code may be held by a commandant of any unit. So it means in that unit only. In terms of section 2F of the statute.
And he alone shall constitute.
Yes, and he alone shall constitute the code. This is one. And 2 is also to some extent relevant. The proceeding shall be attended throughout by 2 other persons, who shall be the officers or subordinate officers, or one of either, and who shall not be as such be shown or affirmed. But they will only see the proceeding, they have no role to play in summary security force code.
Yes.
But 71, 72 and 73, the powers conferred by these 3 courts Your lordship will get that 72, 73 and 74.
We are concerned with
74. Subject to the provision of subsection 2, a summary security force code may try any offence punishable under this act. Now, my lord, your lordship will find under this act, where is the punishment? Section 48 is the punishment. My lord, kindly turn to section 48 once. But in our case, the charge was the violation of section 40. But the yes.
Yes.
But section 40 says violation of good order and discipline. That is the charge against the respondents. And 48 is the quantum of punishment which can be avoided. In our case, your lordship will find the SSFC code hold from dismissal of service, that is 40 in terms of 48C. This is the quantum of the punishment has been given by the SSFC code.
48C.
C.
That is dismissal.
Yes, in our case, dismissal only. So I just wanted to draw your lordship's attention. The court has the power for dismiss someone from the service in terms of 48 subclause C. And commandant alone, he can hold the SSFC code. That is in the statute itself. And the charges was against the respondent for cattle smuggling. This was the charges which falls under sections 40 of the BSF Act.
Yes.
40 speaks about violation of good order and discipline. As because it is a discipline force, which the BSF is primarily formed to give security to the border. So any order which has been violated by any person, which will come under section 40 for violation of good order and discipline. As
Yes.
because BSF is a discipline force.
Yes, yes.
My lord, got it. Now, my lord, I want to draw your lordship's attention to see, my lord, rule 16 subclause 5. The disciplinary power of the commandant. My lord, got it. Command section 5, disciplinary powers over a person subject to the act shall be exercised by the commandant of the battalion or unit to which such person belongs or the officer of whom commandant has developed in accordance with sub-rule 2.
Yes.
So, my lord, sub-rule 2 says if the commandant is not available, then my lord, the second in command will hold the disciplinary action.
In the contingency.
Yes.
So there may be contingencies where the person who conducts the proceeding may not preside over the summary security force code. That is also a contingency.
A contingency, my lord, in exceptional circumstances this is. But generally, your lordship will find section 60.
No, Mr. Mojumdar, herein, please tell us, first a charge sheet is issued. First a charge sheet is issued.
Yes.
By the commandant.
Yes.
Commandant then conducts the inquiry, taking 2 persons can be the recording officers. Now he passes the inquiry order. After inquiry, he issues the final order of punishment.
One by one, I shall place the sections also.
Yes, yes.
But kindly turn to now section the rule 45. Everything will be clear.
Rule 45. Yes, rule 45.
Chart sheet. Kindly see chart sheet first, 44, then 45. Where it is alleged an officer or a subordinate officer has committed an offense punishable under this act, the allegation shall be reduced in writing in form set out in Appendix 6. Now kindly turn to Appendix 6. Who is the signing authority? Kindly say it once. In my book, it is page number 121, Appendix 6. It is attached to the rules. Got it? Appendix 6.
Yes. একই বলছি আমাদের তাহলে 112
Yes. Appendix 6. Yes. Signing authority is the Inspector General, Deputy Inspector.
No, before that, the commandant of the battalion. When in exceptional circumstances, when it is tried by the General and Petty Security Force Court, then the Inspector General. Got it?
Yes.
Otherwise, it has to be by the commandant in normal cases.
Charge sheet will be issued by the commandant. Yes.
Now, 45, hearing of the charge of an enrolled person. Rule at 4
Yes.
The charge shall be heard by the commandant of the accused in the following manner. The charge and sentence of witnesses, if recorded, shall be read over to the accused. In our case, it has been done. If the written statement of the witness are not available, or whether the commandant consider it necessary to call any witness, he shall hear it of the so and so. Whenever the witnesses are called by the commandant, the accused shall be given opportunity to cross-examine them. Thereafter, the accused shall be given opportunity to make statement. After hearing the charges, commandant may award any punishment as is empowered to award. In our case, I have shown your lordship, the commandant is empowered to award for dismissal of service. As per the statute, the commandant is empowered to file charge sheet against the accused, as well as per the statute, section 70 says he alone can hold the SSFC code. As because this is the disciplined force, your lordship can visualize the situation. If a battalion who is in a battlefield and he has heard of the commandant, any subordinate officer, if he is guilty of an offense, it is very difficult to punish him and call someone from the outside and hold the court. That is the reason the statute has held. The power has been vested to the commandant himself. So the commandant, the head of the unit, he can file the charge sheet as well as he can hold the SSFC court. That is the statute, Milord. And hearing of the charges also has to be done by him only. And Milord, I shall place few judgment
So
also.
Here after hearing the charges, he passed a punishment
Yes,
order.
he has passed the dismissal of service.
Thereafter, why did he go to the summary security court?
No, But after the charges, but after the charge being framed, then my lord, the entire matter has been given to the SSFC court has been formed.
Under which provision?
Yes, section 70.
Section?
70.
Section 70.
Yes. Of the act.
That is summary security
Force
force
code.
definition.
Yes.
No, we are asking after the punishment order is passed.
Yes.
Why is it?
Punishment order has to be passed by the SSFC court.
No, kindly come to you are showing this provision. Rule 45.
Yes. Well, 45 2 subclause 4. Well, kindly see.
Down. Rule 45.
2 subclause 4. After hearing the charges, subrule 1, the commandant may
dismiss the charge, remand the accused, award any of the punishment.
Punishment.
In this case, he awarded.
No. He was not awarded. Remanded him for trial by a summary.
So he did not award any punishment.
No, summary security. When he was holding the post as a commandant in summary security force court, then the dismissal order was passed.
Dismissal order was passed by the commandant as the officer conducting the summary security force.
Yes, your lordship.
Now, I am asking you, did he award any of the punishment at the disciplinary proceedings
No.
stage?
He was recommended enter issue before the SSFC court.
That is, he exercised power under 45 to Roman 4.
Yes, my lord.
So he remanded the matter.
Yes, he remanded the matter.
Where is that order of remand? Where is that order of remand for trial? Dismiss করে দিন।
After passing the order of dismissal from service, the matter was placed before higher authority for confirmation.
No. This is not a procedure, my lord.
ও করতে পারে, অ্যাওয়ার্ড করতে পারে, ডিসমিস করতে পারে, রিমান্ড করতে পারে টু সামারি সিকিউরিটি। ও কোনো অ্যাওয়ার্ড করেনি, ও পাঠিয়ে দিল, রিমান্ড করে দিল।
রিমান্ড করতে পারে সেই লোক নিজের কাছে রিমান্ড করে দিল।
Why, my lord, I am telling your lordship?
রিমান্ড করেছে to the commandant of the unit.
Because he has to give a
ওই কমেন্ট
ওই
কমেন্ট
রুলই if the rule provides me বাইরে যাবে
না রুল নয়, রুলটা বোঝানো
opportunity of hearing দিতে হবে। Because my lord, the accused has to give an opportunity of hearing.
That is another aspect of the matter. We are coming to that portion.
No,
If I take example of one, that officer in charge. So who will be the officer in charge? Officer in charge of a particular office. Officer in charge with reference to a office means the officer in charge will discharge the function of an officer of that office. It is the definition.
Yes.
Now, a trial can be conducted by any officer in charge. Whether that can be construed that officer in charge of that officer.
Yes, my lord, this is a special act. So it has an override effect to the general act, my lord. So what your lordship is giving.
Am I
correct? No, I understand, my lord. My lord, what your lordship is applicable, what your lordship is saying, that is, my lord, squarely applicable.
That means like any would be that in initial section 2F, and the any of that 70 would connote the same meaning.
Well, this has been clarified.
Answer lies here.
Well,
of the unit.
Yes. Well, this has been clarified by the judgment of the Honorable Supreme Court. Same point.
Commandant is meaningless. Commandant of which unit?
That unit only.
Officer in charge is meaningless. Officer in charge of which office?
Well, commandant.
To define the word officer in charge, the legislature has used the sentence that officer in charge with reference to a particular office means will discharge the function of officer in charge of that office. Now 70 says the trial would be 70. Because if a person become a complainant, and if that person is allowed to be a judge, then the possibility of prejudice or possibility
My lord,
of
this exactly your lordship's query has been answered by the Supreme Court. My lord, kindly see this.
yes, yes,
My lord,
that is the
yes,
view of the learned single bench.
yes. My lord, which is
Let us
totally
address this issue first.
yes, yes, my lord.
This is
Then
your
we-
only issue.
Yes, this is the only issue. Other score, my lord, I have succeeded. My lord,
Oh, yes, we have to read.
Which
my lord,
paragraph you are?
my lord, enter judgment I shall read, my lord, because this is exactly on the same point. Exactly on the same point.
Take us to the relevant portion.
No, we have not yet understood that who did the, in course of the disciplinary proceeding after hearing the charge, did he pass any or award
No.
punishing the person?
No.
He remanded it.
Remanded
So
him
please
to
show us that order of remand to the security court.
My lord, it is there, my lord, in charge, the order of
Please show
charge.
us
Yes,
that.
my lord, just 1 minute.
Then go to the judgment.
Yes, yes, yes.
Please show us that
My
page.
lord, kindly turn to,
Uh,
my lord, page 60 first.
60.
Page 60. Very good. This is convening order for.
Convening order for the assembly of a SSFC court.
We are not on the.
No,
we are asking you.
Final order.
We are asking you what order did he pass under 45(2)?
This was the order, my lord. Kindly see it, my lord. The details of the officers and SO as mentioned below will assemble and headquartered so and so for the purpose of trying by the summary security force court the accused persons named and margin the presiding officer on so and so, attending trial is so and so, interpreter will be so and so, then friend of the accused is so and so, and then it has been signed by the so and so.
So this is the order of remand according to
Yes.
you.
Yes, my
The
lord.
constitution of court. Is the order or constitution of the court. Final order of dismissal. Who passed? 63. Page 63, your lord.
Final order of what, my
Page
lord?
63, my lord. Dismissal.
Yes, 63, page 63.
Yes, who passed it?
Commandant has
That
passed.
commandant
Yes.
who acted as presiding officer. And this person also issued charge sheet.
But that is permissible under the law.
That we are trying to find out.
No, we are not going against you. We
I
are
know,
wanting to ascertain
Yes,
the
yes.
fact.
I understand.
So this page 63 is the final order passed by the security court.
Yes.
What order is held on Ato? Committed by 40 awarded and found guilty of person. The findings and promulgated to the accused on them. Very good. Now then, where is the order of remand?
Order of remand.
Remand to the CFTC to the
Yes, my lord.
45(2) order. It is not there.
As because they have filed the writ petition. They filed the writ petition.
Atu sir, this is a vital. This is a charge. If
It is the charge sheet.
No, charge sheet is page 60.
Page no page
59.
60 is
59 is the charge sheet.
Yes, Mr. Ghosh, you have not brought on this on record. Where is the charge sheet? Where is the 45
paper book?
No, we show us the 45(2) order.
No, Mano, there are two orders, I'll tell you, Lordship. One is the charge sheet and one is the final order of dismissal.
No, that is safe. That is security court.
Yes.
We are wanting to know was any order passed under 45(2).
No, 45.
45(2) says that after hearing the charge, 45(2), rule 45.
Well, this is. Well, kindly see, well, just now I have handed over page 37 that bunch.
Rule 45.
In terms of 45(2).
Rule 45.
রিমান্ড চাইছে
না না দেখে নিচ্ছি
ডিসমিসও করতে পারে, রিমান্ডও করতে পারে। জানতে চাইছি রিমান্ড করলে তবে না সেফটি সিকিউরিটিতে যাবে।
আবার এনি অফ দ্য পানিশমেন্ট
একটা করতে পারে,
আবার সেটাই করেছে।
না ডিসমিসালটা করেছে হচ্ছে তো সিকিউরিটি।
এই তো সিকিউরিটি কোডটা
ডিসিপ্লিনারি প্রসিডিং যেটা আরম্ভ করবো, এভিডেন্স রেকর্ডেড হলো, তারপরে কি হলো? রিমান্ড হলো তারা সেফটি সিকিউরিটি কোড নিচেই হলো। সেটাই হ্যাঁ
ওই
ওগুলো
যা
তো
সিট করেছে ওই নিজে করতে হবে।
45(2) বলছে যে সবকিছু শুনানি টুনানি করে ও কি করবে, এই যে অফিসারটা করবে
না না ও বলছে এই জায়গাটা চাইছে জজ সাহেব রিমান্ড হিম ফর ট্রায়াল বাই সিকিউরিটি ফোর্স
হ্যাঁ সেটা তো তাহলে ও ওই অর্ডার অফ পানিশমেন্ট রিমান্ড করেছে না অ্যাওয়ার্ড পাস করেছে অফ দি পানিশমেন্ট, where is the punishment order?
Well, at page, your lordship will find 63.
That is page 63.
63.
So what is your case? Is your case is this that there are four punishments, four things you can do. Rule 45, you can do four things. What is that? Kindly come to 45. Hearing of the charge against an enrolled person. Now 45(2). After hearing the charge under subordinate, the commandant may. What are the options? Award any of the punishment.
Which is empowered to award?
Dismiss the charge. Remand the accused for preparing a record of evidence or for preparation of an abstract of evidence against him.
Remand the accused for preparation of record of evidence.
Oh.
Page number 37.
So next is remand him for trial by a summary security force court.
Yes.
What I am wanting to know is in exercise of 45(2), was there any order except page 60?
Well, just now I handed over a bunch. Your lordship will find in page 37.
Is they be given to whatever is being handed over? The copy
All thing was handed over to you at the time of,
No.
37.
You will never give any wrong.
well, it's just the bunch which I have given.
Into months games.
They will be benefited by the copies of whatever documents are being handed over. And we have not got all these documents which are being handed over by my learned friend.
Acha, let us take us to the judgment facts. Please take
Judgment.
us to the
Judgment of a single
judgment
bench.
which you are relying.
Oh, yes, same.
To us, let
Yes,
us see
my lord.
what.
Well, kindly see. Well, I'm reading in its entirety, my lord.
This is
No,
a
no, you come to page 5, internal page 5.
Yes.
From top you read the
Now, if you want to, your lordship want to, my lord, kindly see page 4. Well, at page 4, last para, your lordship, kindly see, your lordship will understand it.
Page 4 last paragraph.
Last para. In view of this court, the single bench of the High Court erred in law in interfering with the action taken against the respondent. Here the allegation of bribing was there.
Yes. Now,
The question involved in this appeal is whether the commanding officer of the respondent suffered from any disability or disqualification from trying the respondent as a summary prosecutor, and he has signed and issued the charge sheet. The same issue.
yes, same issue. Yes.
Same issue. Exactly on the same issue. Now, my lord, kindly see, everything has been discussed. The Supreme Court order also been discussed. But may I read it, my lord, if your lordship permit me? The provision of section 70 of the Border Security Force Act 1968 are parametria with the section 116 of the Army Act. In Union of India versus Dinesh Prasad reported in so-and-so, it was contended that an order of dismissal by the summary court-martial was in violation of the principle of natural justice. This court held that there was no violation of principle of natural justice, no illegality has been committed in convening the summary procedural martial by a commanding officer, nor the conduct of the summary court martial. The court did not find any reason for interfering with the order of dismissal, and accordingly, they allowed the civil appeal and set aside the judgment of the single bench and also by the division bench of the Calcutta High Court. The High Court. In Union of India versus so-and-so, reported in so-and-so, the Delhi High Court has held in cases of concerning trial of disaster dealt with the regulation of 381 of the Defence Service Regulation, a specific explanation has been carved out, enabling the commanding officer of a unit other than one which has been accused belong to convene the constitute and complete an SCWM. Bearing the exception, according to the High Court, it was the commanding officer of the unit to which the accused belonged was empowered to convey, constitute and complete an SCM. The High Court further held that for convening the SCM, it was imperative to immediate action for manifest necessary. In aforesaid circumstances, this court held there is no imperative as the SCM be conveyed, constituted and completed by the commanding officer of the unit which the accused belong. It was competent and permissible for the commanding officer of the unit to which the accused were attached or sent on attachment for purpose of trial to try such accused for convening, constituting and completing SCM to manner to know that is strictly within the confines of section 116, 120 of the Act and other statutory provision. This court endorses the view of the High Court of the summary court martial was an exception and a case must be for immediate action. The reason to convey a summary court martial must be followed by well articulated reason or record itself must justify such resort. In the instant case, the reason to convey summary court martial are reasonable, well articulated. The nature of the charges justified the resort to summary court material. Perhaps it would be pertinent to refer the paragraph 26 and 27 of the judgment so and so to appreciate the issue of the aforesaid case. Now 26 and 27 of the judgment was quoted. Then, my lord, the judgment of Vishaka Peria Singh, there is no assistance to the respondent. The High Court clearly fall in error interfering with the disciplinary action against the respondent, more so in absence of the explanation, not to speak this particular explanation with regard to deposit of so and so in the bank account of the appeal is accordingly allowed, the appeal judgment is set aside, the judgment of the order of single bench of the writ petition also set aside. So, my lord, the Honorable Supreme Court also, my lord, upheld the proposition of law that the commandant, who is the, my lord, the head of the unit, who can file the charge sheet and also, my lord, hold the SSFC code. Oh, my lord, I got your lordship's query, my lord. I got your lordship. I was just looking for it. That bunch of money I handed over to your lordship. Kindly turn to page 37. 37 is the, my lord, starting. Yes, but this is in terms of 45.
We don't have any document as to what is being handed
Everything was handed over to them.
No. May Mr. Mitra be asked for? We do not have any knowledge of what documents have been handed over.
We shall.
My lord, kindly see the appellate forum's order. My lord, this point they have never taken, that copies was not handed over to them. And this was held by the single judge also. This at the time you cannot take this point. Now they are saying that nothing was handed over.
Document that has been handed
now what you have handed over.
No, it was there. Enter proceeding has to be handed over.
What you have handed over.
No, this is a procedure. It has been handed over to them. And my lord, when they went before the appellate authority, there also it was recorded, enter the document which handed over to them. In the statutory appeal. Now before the writ court also, they did not take any point that no document was handed over to us.
No. What
You are showing us this document.
Yes.
What I am wanting.
We will
give him. We'll give him a copy. We'll give him a copy. No problem.
That at the time of trial.
But kindly turn to page 37. This is in terms of
the statutory appeal. Was this challenge taken?
Never it was taken. And this point was also never taken, which your lordship is looking into.
None of this was taken. It was only on.
I shall come one by one, my lord.
Yes, what
first, my lord, kindly see. This is rule 45.
Sentence by the court. This is page 37.
Page 37. আরে ওই জায়গাটা বের করো না, জজ সাহেব যেটা দেখাচ্ছিলেন আমাকে 45.
এগুলো দিকে
হ্যাঁ, rule 45 your lordship was
supplementary. না, এখানে বলছে question involvement. Question is whether commanding officer suffered from any disability or disability. This
commanding officer of the respondent of the particular unit. She signed and issued just.
সেটা is not a disability কিনা সেটাও decide করেছে। তো মিস্টার
Two document.
What
document in terms of section 45(2),
হ্যাঁ
Roman 3, remand of the accused for preparing a record of evidence or for the preparation and abstract of evidence against him. In terms of 45(2), Roman 3, page 37, my lord, we have done. Kindly see it.
Page 37 is what? Receipt. Please.
Yes, yes. My lord, the record of proceeding before the commandant under rule so and so, 45 and 45B. My lord, got it?
No.
My lord, take my copy, my lord.
No, Mr. Mojumdar, you come with a list of documents on which you will be relying, give a copy to him, then we can take it up. A list of documents kindly prepared, because at this stage you have, otherwise you have to bring in documents, but you will be relying upon these documents. We want to see those documents.
Because, my lord, your lordship knows the writ petition was filed by them. We lost, my lord, in the single bench.
So you are not, Mr. Mojumdar, I am asking you for the fourth time. Please show us that under rule 45, what was the decision taken by the command?
My lord, the two document I will place. First, my lord, I shall show your lordship the compliance of 45(2)(3), Roman 3, then 45(2)(4).
So if it is a case of remand, then he does not exercise jurisdiction as regards imposition of punishment. He says that it is a serious offense, it has to be tried by that court. That is why what order, final order was passed by the security
force court.
So at this juncture, which order was passed? Under 45(2), which order was passed?
This one, kindly see it once. See the last portion. Right, the pages are not following.
Remarks. These are the remarks of the commandant and rule.
Kindly see the last, the next page, last line.
Next page.
Last line. It is a continuation of the proceeding.
Disciplinary case against disciplinary case is finalized by holding a safety security. এই প্রভিশনটা 45(2) তে
This is in terms of 45(2) subclause 4.
এবার তুমি যেটা বলছো যে ও চার্জশিট ছিল ওই জাজমেন্টটা থেকে
Only point according to appeal.
Apparently your case does not appear to be meritorious. Why? The basic natural justice principle is that I cannot be the judge in my own case. So if your commandant, as you have shown from the definition, that there is no window to consider that commandant of any other unit is required to conduct this activity. So what is you have to dislodge this thing that you said that it is a discipline force. Our contention, what we are thinking, and as the learned judge has said, that you have issued the charge sheet, you have conducted the inquiry, you have remanded it to the safety security court in view of the gravity of the offense. Now, whether after having done so, you can sit as the presiding officer of that court.
But that the statute permits us. Your lordship knows better than me. That general provision has an overriding effect. This is a special statute.
Yes, Mr. Ghosh, what do you say?
Yes. Before I go to all these, my lord, sections and rules, my lord, may I just give a brief background? My lord, this person, the writ petitioner, he has been in service for 22 years. He has received 16 rewards. And on that particular day, my lord, he was posted for the first time. He went there, my lord, 22 years of service, having received.
Sorry, Mr. Mujumdar, you wanted to show anything else to us?
My lord, I need to, my lord, clarify, there are two other.
Then you please finish it off. Otherwise, I will. Yes, what this document,
42, page
give
40.
us a copy and hand over a copy to Mr. Ghosh. কোথায় গেল ডকুমেন্টে? এইগুলো আমাদের
Page 42, in your lordship's.
এই যে রিমার্কস।
Oh, well, I understand, my lord, two different because there are two cases. One is Ashok Kumar Shor, other is Subhashish. There are two appeals before your lordship.
Two appeal before.
There are two appeals before your lordship.
Subhashish Day.
Charges are similar, only the persons are different.
Vikas Kumar.
Same.
This
Almost
is
all are
Yes, yes.
Vikas Kumar. We are hearing Vikas Kumar.
no Ashok Som.
Ashok Kumar Shom.
They to Subhashish Day and Vikas Kumar.
He is another appeal person. He is another appeal. It is
তাহলে ওর ক্ষেত্রে কি অর্ডার আছে?
same appeal. মানে পরপর শুনলেই দুটো appeal শোনা হচ্ছে। He also dismissed.
এই অর্ডারটা
Same order.
Same.
এই অর্ডারটা ওর নয়।
হ্যাঁ, একদম।
বিকাশ কুমার সুভাষিস।
এটা হচ্ছে কমপ্লেনেন্ট বোধহয়।
না না, সুভাষিসই তো অন্য লোক। কমান্ডেন্ট এটা যে এর আমরা জানবো।
সুভাষিস এবং হচ্ছে অশোক সেন দুজনেই ছিল। টাকাটা নিচ্ছে।
তার নামটা থাকবে রে বাবা।
হ্যাঁ, এই যে সুভাষিস, এইটা সুভাষিস আর একটা
Ashok Kumar Shom.
Ashok Som you have not given. You have given the papers of Subhasis. Both the branches. Same, however, same. Subhasis Day. It is also Subhasis Day. Yes.
Well, can I get, well, just have been told by
yes.
an officer the copy which has been handed over, well, it is pertinent to one your lordship is saying Subhashish and other one is Ashok Kumar Shom.
It is Subhasis, it is also
Ashok Kumar Shom, yes.
No, it is also Subhasis.
No, that is also Subhashish.
You take both.
Read the first paragraph.
No, sir.
Subhashish and
No, this
another,
is-
Vikas Kumar and another.
This is Ashok Kumar Shom and this is Subhashish. My lord was looking Subhashish, Ashok Kumar Shom.
Okay.
Malayasi Bhattacharya was looking Ashok Kumar Shom and this one is Subhashish. The first, the
What?
Oh, আচ্ছা।
এইগুলো
এগুলি
যদি
এই যে এটা সুভাষিসের আর এটা
এইগুলো যদি রেকর্ডে না আনে কিভাবে ডিল করবো?
It has not been included in the paper book.
No,
it is, my lord, they have not annexed it.
No.
They have not annexed it in the writ petition.
Why didn't you annex, sir?
It is the rule that order, my lord, we have annexed to only two documents, my lord. One
Now,
is the,
how will we decide in the absence of these documents?
my lord, with respect, my lord. What our case has been specifically confined to this, that as has fallen from your lordship, that one cannot be the judge of one's own cause. The person who has issued the charge sheet, my lord, that charge sheet has been there in the writ petition, and my lord, the final order of dismissal, which is the final, which has reached finality after the steps taken as per Rule 45. That order is also annexed, my lord. That is these two orders, which goes to show, as has fallen from your lordship, that
Which two orders? The charge sheet and the order of the
dismissal.
security court.
Order of dismissal, my lord, yes, of the summary security.
Of the
court.
security.
Yes,
So rule permits that.
my lord, that is what exactly, my
So
lord.
you tell
I am
us which
satisfied.
rule does not.
Yes.
And my lord,
May I?
just one query, kindly turn to page 61 of the paper book. The record of proceeding has been given to them. As well as the charge. Kindly see, my lord,
Yes.
page 61 of the paper book once.
If my learned friend has finished,
Yeah, walk
then
that way.
61. Yes. This is a record of evidence.
Yes. Copy of the charge sheet, record of ROE proceeding conducted by so and so. So everything was given to them.
9 September 2007.
And my lord, kindly turn to page 65, the statutory appeal which they have preferred before the DG Border Security Force.
দিচ্ছে এটা 3rd সেপ্টেম্বরে পাঠিয়ে দিল সামারি সিকিউরিটি পোস্ট। So after the matter was referred to the summary security court, you handed over the record of documents.
Yes, record of proceeding, all everything, evidence as well as. And now, my lord, your lordship, kindly turn to page 65, the statutory appeal. Not a single whisper regarding this point, which they have now arguing before your lordship.
No, no, I'm not arguing.
Kindly
that
see it,
point.
RST.
My learned friend is,
Let me finish it.
you're making wrong submissions, Mr.
Kindly
Mazumdar.
see page 65, whether this point was ever taken by them or not.
Very good.
Page 65,
Page 65 is the
appeal, statutory appeal, preferred by them. Whether they have taken this point, the person who issuing the charge sheet.
Mr. Mohit, that becomes immaterial because you are inviting a finding on the issue that. So whether
As your
done or
lordship,
not done-
as your lordship. No, just I wanted to bring it
Yes.
to your lordship's
Anything
notice.
else you want to show? Anything else you want to?
Calls from your.
Yes. এবার কে করতে? কি অনলাইনে কি অ্যাপিয়ার করছে আবার? Yes,
Yes, my lord. My lord, first of all, let me clarify, my lord, the misunderstanding that is prevailing. It has not been our case that these documents have not been given. What I was trying to submit is whatever was being handed over by Mr. Mazumdar today before my lords, may a copy of that be provided so that we could follow as to what is transpiring between my lords and Mr. Mazumdar. That was exactly my submission. Now, my lord, coming back to the matter, my lord, if your lordship kindly, just the background, this writ petitioner was there in service for 22 years.
এমনি content.
Yeah. Yes, my lord. My lord, this writ petitioner was in service for 22 years. He's received 16 rewards. This particular day when this so-called traffic smuggling took place was the first day that he was posted at that particular post. He was there for only 1.5 hours between 7 a.m. and 8:30 a.m. Only 1.5 hours.
Yes.
One local person by the name of Kitish Burman wanted to, my lord.
Mr. Ghosh, we need not go into that. That is not the
Just
point.
one more line. My lord, it is only because of this that there has not been any proper evidence at all, because Kitish Burman has given
That's why
evidence
they have
all on probability. All on probability, that
you
is
have
on
not
record.
preferred this appeal. You have not preferred.
No, I have not. What I'm trying to say is the background so that your
No,
lordship
we
can
are
know what it
only
is.
to answer this point,
Right.
which Mr.
Your lordship will
Mazumdar
kindly
chose
come.
from the order.
Your lordship will kindly come to the sections.
Section. Yes. Take us to the section.
Your lordship will kindly come to section 2, the definition portion.
Section
madam.
Section 2.
Yes, of the Border Security Force Act. Of the Border Security Force Act, my lord.
Yeah. Yes, section.
But the definition, 2 subsection 1. In this act, then my lord, I will strongly rely upon the next line, which we usually don't rely upon, unless the context otherwise requires. Unless the context otherwise requires. My humble submission before your lordships would be that this is a particular case where the interpretation of the section would otherwise require to have a different context. This would be in connection with section 2F, commandant. Section 2F and section 70, my lord, these are the two, according to me, the most relevant sections. Commandant. When used in any provision of this act with reference to any unit of the force, means the officer whose duty it is under the rules to discharge with respect to that unit, the functions of a commandant in regard to matters of the description referred to in that provision. My learned friend's interpretation has been that it has to be that same person who has been the commandant of a particular unit. My lord, if that be so, as has fallen from your lordship,
sitting over his own person,
it would amount to.
Where is that exception?
Yes. The section 70, my lord, if your lordship kindly sees.
Yes,
Here, my lord, 2F, your lordship will kindly see.
Yes.
The use of the words that unit has been made. that unit is there. Now, my lord, section 70.
It will be commandant any unit of the force.
Yes. My lord, that in 2F, that unit has been mentioned.
2F, that
that
yes,
unit.
Thereafter, of that unit of which he is the command.
Yes, my lord, the words that unit have been mentioned in 2F, which is not there in section 70. That's an intentional. My lord, your lordship will kindly see, your lordship knows in interpreting, each and every word has to be given importance. Summary Security Force Act. A summary security force court may be held, this organ is may be held by the commandant of any unit. It is not that unit. It is, my lord, it is expansive. It is expansive, my lord. Any unit of the force and he alone shall constitute the court. My humble submission before my lords would be, if the intention was that it would be that particular unit, then the word that would have been used in place of the word any.
Very good.
There has to be some meaning for having put the word any, my lord.
Yes, whatever you have said, with that read to be.
Yes, my lord. To be. Battalion, yes,
Battalion
means a unit of the force constituted as a battalion by the central government.
Now, this unit of a force of the force you will find in 2F.
Yes, my lord.
So, unit of the force is the commandant, is the supreme.
Yes.
And unit of the force and that word which has been used later, discharge with respect to that unit.
Yes.
Now, your section 70 says
any unit.
This any unit is already there.
Any unit of the force. Then
D2F.
Yes.
When commandant, when used in any provision of this act with reference to any unit.
Yes, my lord, what has fallen from your lordship is any unit is covered by that unit.
Yes. No, we are thinking.
Yes. Any unit is covered by that unit. There, my lord, I would humbly beseech your lordship to apply the case of the first line unless the context otherwise requires. In this context, it would otherwise require, and I am supported by a judgment of the Honorable Supreme Court, where it says that in case of any definition or in case of any law, where it is vague and where it is not specific, then, my lord, the provisions of natural justice will prevail. I'll come to that.
Any exception provision is there under this act? Have you found? Because you have studied.
I'll be very frank with your lordship. No.
That in such circumstances it may so.
I have not. I'll be very candid before my lord. I should not make any wrong submissions before my lord. There is no exception. The only stress that I would like to draw your lordship's attention to is the word any unit of the force. Otherwise, my lord, it does not make any sense. Any unit is the only, my lord, expansive word that has been used, or else this particular word would have been that instead of any. That unit instead of any.
Yes. Now, how do you overcome this?
Yes. And
how do you overcome this judgment?
No, this judgment is not. I'll tell you, lordship, there are judgments. This judgment has been handed over just today itself. This judgment, with deepest of respect, can be dealt with very favorably. My lord, now, my lord, I'll take your lordships to certain other sections, which have also been referred to by Mr. Mozumdar, my learned friend. Section 68 and 69, composition. What has been the intention of the legislator in composing these two courts? It has not been a single person or the same person. 68, composition of General Security Force Court. A General Security Force Court shall consist of not less than 5 officers. It is not a single person. That has not been the intention. Each of whom has held the post of Deputy Superintendent of Police for not less than 3 whole years, and of whom not less than 4 or of a rank not below that of a confirmed deputy superintendent.
These two courts did with major punishment.
Yes.
Whereas summary security force did empowered to impose minor punishment. Dismissal is a minor punishment in BSF.
My lord, what my submission has been in trying to draw these two sections is that, my lord, what has been the intention of the legislature? Has it been the composition will be made by only one person and that also the same person?
The first one is not acceptable. Can the constitution be one person? Yes, that is provided.
The same person or not?
The only, yes, your argument is only whether same person.
I'm obliged. I'm obliged. That is my main point. And
so
also,
why don't you come to pat on the point? What is your judgment? You show us now. What is your judgment?
Only 69. I'll
bring it out from your.
Only minus 69. Only 69. The composition again, why not less than 3 officers? I'm just showing the intention.
But you're saying yes.
Yes.
That we
now it's going to sink in. Now, my lord, your lordship will kindly is the judgment of.
Sorry.
This is. My lord Mohendra Singh Gill, my lord, only the relevant portions.
Which one?
Mohendra Singh Gill versus Chief Election Commissioner.
Oh,
this will be with regard to, my lord, natural justice as to whether if there is no specific provision or mention, then what will prevail. My lord, only the relevant portions, paragraph 46, 47, 49, and 53. Paragraph 46, your lordship will kindly come. Paragraph 46. That is at page 433.
Paragraph 46.
Page 433, my lord. It's a very longish judgment. Only dealing with natural justice. If I may just read, my lord.
Mr. Ghosh, you will go to your judgments. Mahinder Singh Gill is well settled. This has been relied by our subsequent. How do you come out of the regards of this judgment?
Well, this judgment has not been dealt with by
please go through this.
I will.
Go through this and you tell us how you can distinguish it. Otherwise, argument is confused.
Would I come back on some other day or right now?
Yes, both of you.
Then it has to be after 15 days. Mileage is going to circle.
Oh.
Because this judgment has been handed over just.
Or your lordship can keep this matter tomorrow for half an hour.
Not possible.
Half an hour?
Then after 15 days, what else, my lord? We have just been served, or else, my lord. My lord, only one line. My lord, only one line.
You kindly, Mr. Mojumdar, this
a supplementary
you are
affidavit.
giving it to me. This
And by way of a supplementary affidavit, that document. I understood. That document.
Supplementary affidavit.
Or your lordship can take it as it basis.
Yes. So
you are not opposing that supplementary evidence.
No, then only a copy be served on us. That is the only prayer that I have.
As prayed for, leave is granted to the
appellant.
Leave is granted to the appellants to file a supplementary evidence. Let's say supplementary. আচ্ছা উপরে দিয়ে দাও হার্ড মিস্টার মজুমদার নেট additional appearing for the
no my lord I'm
deputy additional
I'm not additional
deputy additional solicitor general appearing for the appellants and Mr. Ghosh advocate appearing for the writ petitioner respondent number 1 sole respondent
sole
just one clarification last day that I have handed over 2 more judgment to your lordship. One by Delhi High Court Division.
I will take first of all. Yes. As a key let such supplementary affidavit be filed within 2 weeks from date with a copy to Mr. Ghosh. List the matter for further consideration under the same heading in the daily supplementary list of this court on 12th December.
A time may be fixed at 2 p.m. At 2 p.m.
11 তারিখ করে দেবো। 11 December, if he on 11 as fixed at 2 p.m. And first of all, you have relied upon Mohinder Singh.
And my lord,
Acha, which are the judgments you are
the two
relying?
judgment I have handed over.
You handed over earlier one.
Division
Delhi
bench,
High
Delhi
Court.
High Court, same point, same issues.
Delhi High Court and
And
Anil
our High Court
Kumar
single
Tiwari.
bench.
Anil Kumar Tiwari.
Yes,
Vishwajit,
Yes,
Justice
ma'am.
Vishnu.
on the same point, squarely applicable in our case.
my lord, I'll be relying on 2-3 more judgments. That give me the liberty.
Advance copy may be given to me, so then we can conclude it on that day itself.
I hope this practice was followed. I wish this was followed.
না, এটা কালকে সন্ধ্যাবেলা আমাকে দিয়ে গেছে এই judgment.
এটার সাথে আচ্ছা বইটা এখন থাকা হয় না
My lord, mention item number 6, my lord. 6.
Well, that
Then
March
it is
may be
other
taken,
side is my-
we shall give a supplementary evidence.
এটাও নাকি ফেরত yes what you are saying
My lord, the item number 6, my lord, kindly pay for next Thursday, my lord, so possible.
you are the petitioner
I'm the petitioner and the other side is here.
who is other side you are other side no it will be a second week of December
Thursday. And
12th December
my lord, also my lord, 15 and 16 is I am
what you are
petitioner.
trying to tell us tomorrow we will be calling up the matters remind us tomorrow
Lordship.
12.
12.